Singh Pobjoy, King's Counsel, Miss Gayatri Sarathi, and Miss Marlena Ballas. And the defendant is represented by Sir James Eadie, King's Counsel, Mr. Robert Palmer, King's Counsel, Mr. Christopher Knight, and Mr. Aaron Moss. My lords, could I just check that you have the right bundles? You should have...
I think I do have the right bundles, but let's see as we go along, because they can be sent electronically if we get into any trouble. Let me just say one or two things before we start, shall I? We'll be sitting in open court for all of today. Tomorrow at about 11:30, maybe not exactly, we'll be going into closed session until about 3 o'clock, maybe not exactly, when we will go back into open session until the end of the day, which will be tomorrow at 4:20. We have to rise today, I'm afraid, at 4:10 due to another commitment. I wanted just to say that if anybody in court thinks that the confidentiality provisions that have been agreed are broken by mistake, either by an advocate or by the court, which does happen, I'm afraid, because we're treading slightly on eggshells, can I ask either one of you or anybody else who feels very strongly about it to say so? At that point, we will stop the live stream, on which there is a delay, and so no harm will be done, provided you get your point across within 90 seconds. And then we can decide what to do in the particular circumstances, rather than having a particular plan in every case. As far as the court is concerned, we're not really very keen to distinguish between particular levels of confidentiality. We note that in the bundles there are all sorts of levels of confidentiality. I think we'll just have one level of confidentiality, namely confidential and open. We accept, though, that some aspects of the evidence in this case cannot be made public appropriately, and that's why part of the hearing needs to be in private. But that does not detract from the fundamental principle that court hearings in this country are held in public. And we should like to see as much as possible of the legal and factual argument undertaken in open session, with suitable caution being exercised by the advocates to ensure that confidential material is not disclosed. I just wanted to be clear before we start about the importance of the open justice principle.
I'm very grateful, my lord.
Good.
In terms of the structure of my submissions, I'm going to start, first of all, with the relevant legal principles and the case law. At the end of that section, I will address the respondent's notice and the points of law raised by it. I'm then going to address the grounds of appeal in the following order. First of all, ground 1A, and then I'm going to take 1B and C together, and then 1D and 2 together. My lords, before turning to the law, could I make 7 introductory points? The first is to identify some common ground. It is common ground that when RAVC made its February 2020 decision about the appellant's protective security, it did not apply its own terms of reference to that decision-making process. Those terms of reference say that RAVC will base its decision-making on an assessment from an expert specialist body called the Risk Management Board, or the RMB, as I will call it. It is also common ground that RAVC did not get an RMB assessment for the appellant. Instead, RAVC came up with a different and so-called bespoke process, which, as that label makes clear, is not applied to anyone else. I will use bespoke, partly because it's shorthand and partly because it was used in the judgment below, but the appellant does not accept that bespoke means better. In fact, in his submission, it means that he has been singled out for different, unjustified, and inferior treatment. Not only does this bespoke process not involve the RMB, it also involves RAVC considering the reason why the appellant is attending a particular event, even though that is plainly irrelevant to the question of security. This first introductory point is particularly significant because the appellant's case is not that he should automatically be entitled to the same protection as he was previously given when he was a working member of the royal family. The appellant's case is that he should be considered under the terms of reference and subject to the same process as any other individual being considered for protective security by RAVC unless there is a cogent reason to the contrary. Second, it follows from this that the core question raised by this appeal is whether RAVC has given a clear, logical, and convincing reason for departing from its terms of reference and failing to do an RMB for the appellant. The answer to that question is no. Third, the judge's starting point for that good reason question, as I will call it for shorthand, was that the RMB assessment is optional or discretionary. That is wrong. And that fundamental error of interpretation then completely tainted his analysis on good reason. Contrary to the judge's analysis, the RMB assessment is a key and crucial feature of the RAVC process. The requirement to undertake the RMB is expressed, as we will see, in clear and unqualified words in the terms of reference. And we know that there are very good reasons for that requirement, and we know it because of what RAVC's own documents and RAVC's own witnesses say about the distinct expertise of the RMB. Fourth, whilst it is right to acknowledge that RAVC has expertise in relation to matters of protective security, the nature of the issues raised by this case do not require the court to defer to RAVC. There is no separation of powers issue here, nothing that is beyond the court's institutional competence. The judge wrongly deferred to RAVC, and deference is at the heart of the respondent's resistance to this appeal. That is illustrated by RAVC's contention that the starting point for interpreting the terms of reference is a presumption that RAVC knows best. That the court should accept RAVC's understanding of its processes, even when that understanding does not match the words on the page or what RAVC does in practice for others. That is what the judge did, and he made a mistake when he did so. Fifth, RAVC also contends, by its respondent's notice, that the court should not look to see whether RAVC had a good reason, but that it should apply far less scrutiny and just ask whether RAVC's decision was unreasonable. The judge rightly rejected this legal submission, but he did make another legal mistake. And that mistake was to ask whether there was a good reason for RAVC's approach when he should have gone further. He should have applied the test of cogency, and he should therefore have intensely scrutinized RAVC's decision by asking whether the reason relied on was clear, logical, and convincing. Sixth, had the judge done that, he would have concluded that RAVC's reason for not doing an RMB for the appellant doesn't stack up, especially when one looks at what RAVC has done for other people. The lack of scrutiny led to the judge wrongly accepting RAVC's evidence, and that evidence says that a so-called bespoke process makes much more sense for the appellant than the RMB. My lords, that evidence has not come from the RMB, and it doesn't make sense when one considers in detail the expert analysis that the RMB assessment involves. It is impossible to speculate on whether the appellant would be in the same position had he been given the benefit of the process which RAVC's terms of reference mean and which RAVC has given to others. The final point is that the failure to do an RMB for the appellant means that RAVC did not have the expert analysis that it needed in order to consider whether or not the appellant should be treated similarly to those in the other VIP category, or OVC as I will call it. And RAVC did not make a reasonable decision because the appellant's position is analogous to those in that OVC category. Had the judge properly evaluated the evidence, he would have come to that conclusion. With that introduction, I want to turn to the relevant legal principles and the case law. There are 6 key legal propositions that are relevant on this appeal. The first 2 relate to good reason, the third to deference, the fourth to both good reason and interpretation, and the last 2 to policy interpretation. I'm going to just start, my lords, by identifying those propositions and giving you the references to the authorities in support, and I will then ask you, please.
Maybe one of your juniors could let us have those principles written down if they're not in your skeleton?
Yes, of course, my lord. They are in the skeleton. I'm going to synthesise them in a way which I hope is helpful for the court.
Well, if you're going to synthesise them in a different way from the skeleton, maybe we could have it electronically as soon as possible to save our typing it all out.
My lord, yes. I'm sure somebody is doing that.
Take it slowly so that we can understand your new synthesization.
I hope it's not new.
Synthesis, I should say.
I hope it's not new, but let me have a go. My lords, the first proposition is that where a public authority has issued a promise or adopted a practice which represents how it proposes to act in a given area, then the law requires that promise or practice to be honoured by that public authority unless there is a good reason not to do so. And I'm going to refer to this, as the court did below, as the Nadaraja principle. And the most recent key authority in support of that is Himati at paragraph 69.
Sorry, which one?
Himati.
Himati.
Yes. And it's in our skeleton, my lord.
Paragraph 69.
Yes, and our skeleton, paragraph 24, refers to that. And indeed to what I've just said. The second proposition is that the standard of review when considering the claimed good reason is whether the decision maker has shown a cogent or compelling reason which is spelled out clearly, logically, and convincingly. And that is Munjaz, paragraphs 21 and 69.
Spelled out what? Sorry, I was a bit behind you.
Clearly, logically, and convincingly.
That's Mumtaz.
It's Munjaz 21 and 69. Also, Tower Hamlets 35 and Our Skeleton 37.
Which one in Tower Hamlets? Which para?
35, my lord.
Thank you.
And my lord, I'm also going to have a look at the Begum case, which the respondent has relied on as part of that second proposition. The third proposition is that although a court may give weight to or defer to the judgment of a decision maker, the level of weight or deference will depend on the context of the reason, of the decision, and the evidential value of the particular judgments made by the executive.
Evidential value of the particular judgment?
Made by the executive. And that is Carlisle, para 22, our skeleton, para 30.
Sorry, skeleton, Carlisle 32 and skeleton 30.
Yes. The fourth proposition is that the certainty with which a policy is expressed may be relevant to whether or not there was good reason to depart from the policy, and the greater the departure from the policy, the more compelling the reason must be. The key authorities are HZ, para 107.
Mr. Justice Henshaw.
Yes. And Tower Hamlets again, para 35 again.
Yes.
My lords, just before I go on to the fifth proposition, this fourth proposition that I just described explains why it is so important in this case to start with the correct interpretation of the terms of reference. And as you know, as I've already said, we say that the clear and unqualified terms in which the RMB requirement is expressed, the rationale for that requirement, and the way it is being implemented in practice all mean that the threshold for departing from it is high. And that is something which the judge did not properly appreciate. And that is why I emphasize not just that fourth proposition, but that prior interpretive stage before one comes to good reason. Is the final arbiter of what a policy means. Including its scope.
Including scope.
Including its scope. And the meaning to be given to a policy statement is what a reasonable and literate person's understanding of the document would be. And my lord, the key authorities are again Hemati, para 69, Mandalia, para 31, Raisi, paras 123 to 124. And those are in our skeleton at 24 to 25. The final proposition is that there is no general principle that when the court interprets a policy, it must always start from the presumption that the decision-maker's interpretation and understanding of the policy framework is correct.
That's very precise. I mean, just the framework.
That's going to be the proposition.
Okay.
My Lord, the judge was wrong to say otherwise. He relied on Hopkins Holmes.
Sorry?
He relied on Hopkins Holmes.
Yes, indeed.
And I'll come to obviously go through the judgment, but just for the court's reference, that's in the judgment at 175 to 176. And we say that he was wrong is shown by, again, Himati para 69, Mandalia para 31, and a short extract from Dismith, which I hope you've received.
Thank you.
Paras 5, 191 to 192. And again, that's our skeleton 31 to 32. So with that, could I ask the court to please have a look at some of those authorities? Could we start, please, with Himati, which is 2021. It's in the authorities bundle 2, and it's tab 21.
Help me if you could give electronic page references.
So 801, I hope, my Lord, will take you to it.
801.
Yes, so when I give the references, I'm going to give you what you should have in your electronic bundle rather than the pagination internal to the report, if that's
Electronic
easiest.
bundles.
Yes.
Very helpful. Yes, thank you. Himati.
My Lords, this is the most recent articulation of the Nadaraja principle, and I'm not going to take that case up right now. It's paragraph 68. We'll come and look at that later. This judgment not only articulates Nadaraja, but as I've said, it also makes clear that the court is the final arbiter of interpretation, and we also rely on it in support of the no Hopkins presumption. If we can just have a quick reminder of the facts and the outcome from the head note. There was detention pursuant to the discretionary power to detain, conferred by Schedule 2 to the Immigration Act 1971. You can see that, I hope, at letter F in the margin. The claimants sought to judicially review their detention on the ground that it breached a council regulation. And at first instance, and you can see this at letter G, 4 out of 5 claims were dismissed. Court of Appeal allowed those appeals, dismissed the Home Secretary's appeal. The Home Secretary appealed to the Supreme Court, but that appeal was also dismissed. And if we go over the page to page 802, you can see from letter D that one of the reasons the appeal was dismissed was on the basis that the Home Secretary's policy in relation to detention pending removal in Chapter 55 of the Enforcement Instructions and Guidance did not satisfy the requirements of law within the meaning of that regulation. And if I can ask you please to go to page 831.
Find where it says that. Does not have the necessary qualities of certainty and predictability constitute a binding provision of general application so as to amount to law.
Yes. And if my Lord looks further up, you can see 3 lines above D.
Above D?
Yes. Did not establish objective criteria for the assessment of whether such a person might abscond. Contents did not constitute a framework of certain predetermined limits, and so on.
Yeah.
If we could go to page 831 in the judgment of Lord Kitchen, you can see at the bottom of the page the heading Domestic Law.
So Lord Kitchen was the lead judgment?
Yes, he gave the judgment on behalf of the Supreme Court. And my Lord will see that from the top of page 820.
Yes, everybody agreed with him.
So page 831, para 40 is where the description of domestic law starts. And we can see within that, on page 832, para 43, a description of the policy. So that's chapter 55, which we saw referenced in the head note. And then if we can just turn on to page 834 and paragraph 50, you can see there that Lord Kitchen says, and he accepts that the executive must follow the stated policy unless there are good reasons, good grounds for...
Sorry, I'm not with you. Where are you reading?
Paragraph 50, my Lord.
50, yeah.
Page 834.
First sentence, yeah.
Yes, exactly.
Thank you.
So he said that, and then he goes on, and you see this over the next several pages. He analyzes and interprets the chapter 55 that we saw of the policy. And that is the analysis that was in the head note as to whether or not it satisfied the criteria and requirements of the regulation.
Does the type of policy matter? I mean, this is a public-facing, published policy in
Yes.
this case, is it not?
Yes?
Yes. This was not in our case.
No, I'm going to show you an example. Mandalia is an example of a policy that was not published, and in my submission, for the propositions that I have given you, there is no difference. And in particular, I'm showing you this case, as I said.
So just to be clear, your submission is there is no difference, that even in terms of context, the court would not regard a policy of the kind we're dealing with here is different from a published public policy for the public at large, immigrants at large in this case, from something as very narrow as the RAVC policy as a reference we're concerned with here. I'm just interested to know what you say. I mean,
My Lord,
naturally one might have thought that the court would anyway look at the context in which the policy was published, right?
yes, but in my respectful submission, the principle that the court is the final arbiter is not different. That is my point.
Oh no, as to the final arbiter of what it means.
Exactly
Yes,
so, my Lord.
absolutely.
Exactly so.
I'm not sure that's in contention.
Well, except for the Hopkins presumption point.
Okay, well we're going to come to
And we're going to come to that. And as I said, I'm showing you this in part. You will have appreciated that this is a few years after Hopkins Holmes.
Yes.
Hopkins Holmes was 2017, this is 2021. I'm showing you this in part to show you what the Supreme Court did when faced with a policy that had interpreted it, and I'm going to just show you a few other passages to make good my point that this doesn't support the Hopkins
But
presumption.
they asked to consider Hopkins in this case.
No, interestingly they weren't. Nobody even cited it. But could I just return to my Lord's question? I don't want to not answer it fully. So, in terms of the proposition that the court is the final arbiter and that there's no Hopkins presumption, I do say that this is the same, whether it's outward-facing or internal. I will come on to look at what matters when you're interpreting as the final arbiters. And in my submission, it will be purpose, content, that is the text, and context. So, of course, when the court is actually engaging in that interpretive analysis, you do look, in my submission, at the context. And that can include outward-facing, internal-facing, and so on. So, my Lord, I was just going through this section, which starts now on page 835. It's the heading just above paragraph 52, to say that you can see from the pages that follow the interpretive exercise that the Supreme Court did. It goes all the way up to paragraph 74, but I wonder if we could just stop off and look at paragraph 69 first of all. Paragraph 69 is the one that I've identified to you as the basis for the propositions I've given you about Hemati. It is on page 100 and 840. If I could just ask you to read that before I make some points about it.
Is that the one that you referred to in relation to 3 or 4 of your propositions?
Yes, my Lord.
69, let's
Yes.
read it.
Yes.
I mean, you can read it out. It always helps me if you read it out. I know that.
Certainly. I'm conscious that my lords may get tired of hearing my voice.
Well,
but
except that it's only 10 lines, and it may be important for everybody else in court
Yes.
to hear what you're saying.
There can also be no doubt that in this jurisdiction, a policy statement such as Chapter 55 of the EIG has significant legal effects. I have referred to these at paras 50 to 51 above. In broad terms, and as Lord Justice Laws explained in Nadaraja, where a public authority has issued a promise or adopted a practice which represents how it proposes to act in a given area, the law requires that promise or practice to be honoured, unless there is good reason not to do so. Moreover, the court is the final arbiter of what a policy means. There's then a reference to Kambadzi and Mandalia, which we'll come on to look at. It is also well established that compliance with such a policy is enforceable by individuals before the courts. So, my lords...
So you say that's very clear and comprehensive.
Clear and comprehensive in, first of all, setting out the Nadaraja principle, setting out the court as the final arbiter, but then it's a nil return, if you like, in terms of Hopkins. There's nothing there about a general presumption. And this would be the sort of case to say it, because it's an immigration case. And as we'll come on to see, the respondents say that planning and immigration are examples of where the presumption that they rely upon bites. So nothing here. And as I said in response to a question earlier, my lords, it wasn't even cited in argument, let alone referred to by the court. The next authority is Mandalia, which is 2015, and it's Bundle 1, Tab 12, and electronically it should be page 475.
This is earlier, isn't it?
I'm so sorry, my lord, I didn't.
This is earlier.
Yes, this is 2015. And again, just as a reminder, I'm citing it for court being the final arbiter and also the no Hopkins. Again, if I could just take the facts from the head note on page 475, you can see from the top of that there was an applicant for a UK visa and he failed to provide evidence of sufficient funds for the requisite period. You can see that between letters E and F. He only provided evidence for part of that period. And then we can see going down to G that there was a process instruction given to border agency caseworkers, which required that in certain circumstances they ask further questions from the applicant before determining the application, and no such request was made to the applicant, his application was refused. So pausing there, my Lord, this is an example of that internal-facing policy that I referred to earlier. If we go to page 478.
It was unpublished, the process instruction.
Yes.
Yeah, sorry, which page?
Page 478. This is the judgment of Lord Wilson for the Supreme Court. And you can see the question that the court was considering between letters B and C. The question is, did it act unlawfully in refusing his application without having first invited him to supply a further bank statement and so on?
Sorry, I'm not not with you where you are. Which paragraph?
It's the continuation of paragraph 1.
Oh, right.
And it's page 478 between letters
between B and C. Sorry,
Yes.
I thought you said D and E. Yep, got it. Thank you.
The relevant legal principles start at paragraph 29 on page 484. And you can see from the top of page 485, and again it's between B and C, that Lord Wilson refers to the applicant having the right to determination of his application in accordance with policy. Now generally taken to flow from a principle no doubt related to the doctrine of legitimate expectation but freestanding, which was best articulated by Lord Justice Laws in Nadaraja, and we there have set out that paragraph 68 from Nadaraja.
Yes.
And then the key paragraph that we rely on is 31, which is at the bottom of that page. And if you could have a look between letters G and H, please.
Yes.
Lord Wilson says that the Secretary of State does not say there were good reasons for not following the policy, but that properly interpreted the instruction did not require the caseworker to alert the applicant. And he then says that the search is for the proper interpretation of the process instruction. You see that at the bottom of the page. No more and no less, he says. Indeed, in that regard, it is now clear that its interpretation is a matter of law, which the court must therefore decide for itself. And over the page, previous suggestions that the court should adopt the Secretary of State's own interpretations of her immigration policies unless it is unreasonable, made, for example, in Gangadeen, are therefore inaccurate. And we say again, my lords, that this paragraph shows that the respondent's reliance on Hopkins as creating a presumption of general application is not a good one. And just so the court has the answer that was given to that question that we saw in paragraph 1, it is in paragraph 36 on page 487. And you can see that the conclusion reflects the fact that the Supreme Court interpreted the policy for itself and said that the process instruction obliged the caseworker first to have invited Mr. Mandalia to repair the deficit in his evidence. My lords, this case illustrates the point that procedure may in itself provide a benefit, because the right to file more evidence in this case, in Mandalia, was part of the procedure but it was also a benefit. And similarly, we say, in the present case before this court, that the need for an RMB assessment is part of RAVC's procedure, but also a benefit. And that is relevant when we come on to look at the good reason part of the analysis.
Do you think it could be said against you that you're trying to put public law into a very inflexible series of boxes, which the judge at paragraph 178 and following declined to do in this case because of the context, and he made that criticism effectively of your submissions below. I mean, the cases you've shown us so far are all immigration cases with policies that apply to, even if not published, apply to hundreds of thousands of people, and a process in immigration does have to be fair. All processes have to be fair, but the processes don't necessarily have to be the same in every type of case, because fairness is not put into little self-contained boxes. And I'm just interested to know whether you would accept the criticism that so far you're adumbrating really quite inflexible, monochromatic rules that are applicable to everything called a policy. And we've, for the avoidance of doubt, looked very carefully at the underlying documents in this case. And the so-called policy is, in fact, called terms of reference.
Yes.
And is quite short and not the same, anyway, as many of the immigration policies many of us have had quite a good opportunity of looking at. What do you say about applying these sort of tightly drawn principles in this situation?
My Lord, I would not accept that criticism if it were to be made. And the reason for that is I don't accept the characterization that what I've described to you are tightly drawn boxes. What I've described are principles or propositions that guide the way the court should approach this particular case, involving, as it does, the interpretation of a policy. I entirely accept that each policy will be different, and what it requires in terms of the court's consideration will be different. And I am going to come on to look at what, on the facts of this case, I accept you should be looking at. Contrary to the characterization in the judgment, I am not pressing on you a mechanistic, literal interpretation. And the reason for that, and obviously I will come on to develop this, is I don't say that we get the meaning from the four corners of the document. I don't say that. That is why this isn't about boxes or tight adumbrations which may be a straitjacket in a public law context. This is to say, and as my Lord said, it is accepted that the court is the final arbiter, subject to the difference on Hopkins. The question is how you go about that job. And in my submission, you don't defer to what RAVC thinks the policy means or says, but that's one end of the spectrum that the respondents are pressing on you. I'm not going to the other extreme end of the spectrum to say, well, just look at the words on the page. Don't look any further. Look at it as if it was an act of parliament or a contract, although, of course, even in those cases, one doesn't just look at the words on the page. I am going to be inviting you to take a much broader lens, to look at the purpose as well as the content. And when we come to look at the context, I will identify 4 strands that I say are relevant and engaged. And my Lord will see in due course that those 4 strands reflect the world that we're in of protective security provision, which is obviously different from planning or immigration. So, my Lord, I would not accept the criticism for those reasons.
Okay, thank you.
I want to move now to RAVC, which is 2008. and it is Bundle 1, Tab 6. It's page 224 of the electronic bundle. And you can see from the head note, letter G, that the claimant applied for compensation for detention under an ex gratia scheme, which was introduced in a ministerial statement to Parliament. Home Secretary refused his application. He applied for judicial review. And we can see, if we go over the page, please, a few lines above letter B, that the Divisional Court dismissed the claim on the basis that it was for the Home Secretary to decide the meaning and scope of his policy, provided that his interpretation was one which a reasonable minister could reach. And then you can see, if you have a look at a few lines above C, that the correct test in interpreting the ministerial policy statement was to ask what a reasonable and literate man's understanding of it would be, and not whether the meaning attributed by the minister to the words of the policy was a reasonable one. It was for the court to decide what the ex gratia scheme meant on the basis of what a reasonable and literate person would understand the circumstances to be. And could I just give you, for your note, that the statement is at paragraph 4 on page 231. And it makes clear that there was no underlying statutory provision in that case.
Yes.
And then if we can have a look at the two paragraphs which I've cited to you, paragraphs 123 and 124. They are on page 258. And in 123, you can see that the Court of Appeal say we shall use the ex parte web text, whilst accepting that it could be worded in a more modern way. That text that they have referred to is in paragraph 108, which is on page 254. And it's in the quotation at the bottom of that page. So if you could pick it up 3 lines from the bottom. The government has made funds available for the payment of compensation without being under a statutory duty to do so. It follows in my judgment that the court should not construe this scheme as if it were a statute, but as a public announcement of what the government was willing to do. This entails the court deciding what would be a reasonable and literate man's understanding of the circumstances in which he could, under the scheme, be paid compensation for personal injury. And then if we go back to page 258, you can see the questions that are posed there in paragraph 124. What does the scheme mean? What was its purpose and scope? Who is the minister intending to compensate? We've already set out its terms at para 4 above. The purpose of the scheme, as set out in para 1, was self-evidently to compensate those who had spent a period in custody resulting from a serious default on the part of a police officer. So that point that is being made there, namely that the terms of the policy define its scope, because that's what the court is doing, it's interpreting who comes within the scope. We see that there, those who had spent a period in custody and so on. That is evident from the observations of Lord Steyn in the McFarlane case, which is set out earlier in the judgment on page 256. So if you go to 256 and have a look, please, at letter G, this is the quotation from Lord Steyn, who was dissenting in that case. He says, the decision maker, here a minister, may depart from the policy, but until he has done so, The citizen is entitled to ask in a court of law whether he fairly comes within the language of the publicly announced policy. That question, like all questions of interpretation, is one of law. Now, although he dissented in that case, this dicta has been followed by courts and accepted to be good law. And I just refer, in support of that, to my Lord Justice Bean in the Secretary of State for the Home Department in JB, which is 2022 EWCA Civ 1392 at para 56.
So is that not in the bundle?
No, my Lord, it's just...
Give us the reference again then.
Yes, of course, certainly. It's 2022 EWCA Civ 1392.
Yeah, can it be provided to us electronically?
Yes, of course, and it's para 56. So that is RAVC, and could we then go to Hopkins Holmes, which is 2017?
Sorry, just before you leave that, could you read the bottom to the end of 124? I think you were on page 258.
Thank you.
Well, my Lords, I've already addressed that point. The appellant is not pressing a legalistic interpretation on this court. I've already said I'm going to come back to purpose, content and context. Could we then go, please, to Hopkins Holmes, Authorities Bundle 2, tab 16, and it's page 622, electronically. The respondent relies on this for paragraph 22, which is the uncontroversial proposition that a policy is not to be interpreted as a statute or a contract. I've already shown you language to that effect. But the respondent also relies, and I will show you this, on paragraph 25. And it is said that that establishes a general principle that, and I quote from their skeleton, the court should respect the expertise of specialist decision makers applying a policy and start at least from the presumption that they will have understood the policy framework correctly. That's para 12 of the respondent's skeleton. And the judge accepted this in the judgment at 175 to 176. And we say that is wrong, and this case is not authority for that proposition that the respondents rely on it for and that the judge accepted. The case involved a planning policy, again, just taking the facts from the head note.
There are an infinite spectrum of decision makers, running from a Home Office official making decisions about hundreds and thousands of immigrants who absolutely require to be able to follow closely the words of a clear policy in order to be fair to everyone, through planning inspectors who are decision makers of great expertise and with long experience in making planning decisions, to whom some deference is obviously, or some respect is obviously due, through to people who make decisions about a very small cohort of people and are no doubt expert in national security.
Yes.
I mean, they're not the same.
No, and it's no part of my case to try and say.
It's more nuanced.
Absolutely, absolutely. And I'm at pains to emphasise.
I'm not saying Hopkins is wrong.
No, not at all. I'm saying that I'm saying that the way in which it is relied upon by the respondents is wrong, because Hopkins is about planning, and the presumption that Lord Carnworth identified that I'm going to show you is about planning, and it's about the specific context of that case. What the respondent says is, no, this isn't just about planning. You can pluck this out of Hopkins, the planning context, and you can plug it in to protective security. So you, the court, are being invited to accept that your starting point, that is the way it is put, your starting point is the presumption that they know their policy. And I say that is wrong in terms of being a general starting point which creates a presumption in every case. So it is the respondent's case that is not allowing for nuance here. They are the ones pressing upon you an absolute presumption. So, my lord, I don't say Hopkins is wrong. I say Hopkins is limited to what it decided. And that is why I say we didn't see it in Hamati, we didn't see it in Mandalia, and that's for the very good reason that they weren't planning cases.
But, I mean, the question of whether it's applicable, in other words, something similar is applicable, is a matter for the court in every case.
Yes, as part of context, absolutely. Yes, and also there is a more general question, and I've addressed you on this, and I will come to show you Carlyle, which is this general notion of deference or weight. And again, it's no part of my case that RAVC does not have expertise. I accepted that in my opening remarks. But, my lords, one of the key ironies about this case is that the respondent presses on you RAVC's expertise whilst ignoring the expertise of the RMB. And that is something which I will come back to, because all that we are saying is your own process says you have to defer to the expert specialist body that your documents explain the importance of.
Let me just say something that may help you to address your submissions effectively later. I shall want to understand why you say that in this case any determination by RMB would have actually affected the way in which RAVC dealt with the issues of the claimant, particularly in circumstances where he was doing what he was doing, because the RMB assessment, as I understand it,
yes,
is obviously it's a very detailed threat assessment, risk assessment, detailed analysis of all sorts of aspects of what's going on in the world. But what I'm slightly concerned about at the moment is, again, putting it into discrete boxes and saying the RMB is relevant to what RAVC was considering about this claimant in these actually unique circumstances.
Yes, and my lords, I will come to deal with, I hope, precisely that point. I do say this, though, given the nature of the submissions, that will be in closed session.
No, well...
So I will come on to that, but it won't be today, is my point. It will be tomorrow. Yeah, okay. But I hope that when we go through the documents, I will try and flag, especially in terms of the documents that the court has and is able to see, the parts that will pertain to that.
Will be relevant.
Yes.
Yes, well, that would be very helpful. Thank you.
I was just showing you Hopkins and the facts. The context is the planning permission applications, and we can see between letters F and G that in each case the inspector had to establish whether particular policies of the relevant development plans were considered not up to date under the National Planning Policy Framework, and if so, what the consequences for his decision should be. And then if we go over the page to page 623, you can see the finding between E and F. And if I read it out, it's 3 or 4 lines down from E. The court's role was not to be overstated, and courts should respect the expertise of the specialist planning inspectors and start with the presumption that they would have correctly understood the policy framework.
I'm sorry, where are you?
Between E and F, and it's maybe 623.
Yeah, thank you.
And it's 3 or 4 lines up from F.
Yeah.
And the bit I read out was the court's role was not to be overstated, and courts should respect the expertise of the specialist planning inspectors.
Yes, I see.
And so that's essentially the bit that the respondent relies on. But if I can show you in the judgment, and this is the judgment of Lord Carnwath for the Supreme Court. And if we go, first of all, please, to page 633, and you can see, I hope, at the bottom of that page, law and policy. Paragraph 22 refers to the correct approach to the interpretation of a statutory development plan. That's Tesco. That's then set out over the next page, and page 634, para 24. He says, in the first place, it is important that the role of the court is not overstated.
Yes.
And then over the page again to paragraph 25. And this is really the core passage for the respondent. He refers to whether it's a development plan or a non-statutory statement such as the NPPF. They're statements of policy, not statutory texts, must be read in that light. Even where there are disputes over interpretation, they may well not be determinative. Furthermore, the courts should respect the expertise of the specialist planning inspectors and start at least from the presumption that they will have understood the policy framework correctly. That's obviously the bit that I read out from the respondent's skeleton argument that they rely on. And then you can see that he refers to the role and says it's in some way analogous to that of expert tribunals in respect of which the courts have cautioned against undue intervention, and there's a reference there to an immigration judgment. Para 26, recourse to the courts may sometimes be needed to resolve distinct issues of law or to ensure consistency of interpretation. Specialist judges of the planning court have an important role. And then at the end of that paragraph, you can see there that he draws a distinction between issues of interpretation of policy, appropriate for judicial analysis, and issues of judgment in the application of that policy, and not to elide the two. So as to those two paragraphs, we make 3 points. They're in our skeleton argument at 32, but if I can just summarise. Paragraph 26, as I've just shown you, demonstrates and identifies that critical distinction, we say, between the interpretation of a policy and its application, and the role of the court in respect of the former. And we say, secondly, that the analysis and conclusion that I've just shown you, throughout that section, starting from paragraph 22, is highly fact and context specific. It is about planning. Self-evidently, we would say. It is...
Of course, the case is about planning. Why isn't the proposition of general application that the courts should respect the expertise of the expert decision maker and start at least from the presumption that they will have understood their own policy framework correctly?
Because, my lord, that's abdicating, in my submission, your role as the arbiter of the interpretation of the policy. You are entitled, in my submission, to have regard to how the decision maker interprets the policy, but to suggest that that is the starting point and indeed a presumption that has to be overcome by the other party to the litigation is, in my submission, wrong. And we saw that in the earlier cases where they talked about this idea that you start with the fact that the decision maker has applied it correctly unless you can show it's not reasonable. So it's not to say that you don't look at their expertise or how they've understood it, but you don't start from the presumption that they are right. So it is putting...
You don't start from the presumption they're right as to the interpretation if it said they're wrong.
Yes.
Because that's for the court.
Yes.
But don't you start from, if not a presumption, a certain level of respect, depending on the nature of the decision maker,
yes,
or the expertise of the decision maker?
Yes.
Yes.
Yes, I entirely agree with that.
Yes.
And the third point is we don't understand the respondents to say in this case that the interpretation of the terms of reference is something that requires expertise. We understand them to be making a more general point, which is about how it's understood or applied. So in terms of the interpretive exercise, it's not one that needs some specialist input. For example, if the wording was of a technical or difficult nature that could not be construed without some sort of specific expertise. The next authority is De Smith. And can I just check whether the court would be assisted with a hard copy of De Smith? No.
Not in my case.
My lords, this relates to Hopkins and that sixth presumption. And those two passages that I refer to, 5191 and 5192, they reflect, we say, the obvious fact that Hopkins addresses the specific context of planning. And it's the sentence at the very end of 512, namely, the extent to which their lordships' warnings against over-legalisation are relevant in the interpretation of other policy provisions will depend on context. But that is really the short point. The extent to which you can take Hopkins and apply it is contextual, and we say that context isn't here. But again, De Smith does not suggest that there is some kind of Hopkins presumption of general application and does not therefore support either the respondents or the judge's interpretation.
Well, it's just the last sentence, isn't it?
It is just the last sentence, my lord.
Which is what I think you've been saying to us.
Yes, which is why it's edifying to find it reflected in De Smith.
I'm not an editor of this book.
I am not. I hasten to add, I am not.
Sometimes happens.
I've never been accused of citing my own academic work. Not to my knowledge, anyway. My lords...
You can do it, but you just have to be a little self-effacing in doing
Yes.
so.
Yes. Could I ask you, please, now to go to Munjaz?
Yes.
And this is authority for the second proposition I gave you regarding the standard of review, for good reason. It's bundle 1, tab 2, and it's page 18. And I'm asking you, please, to have a look at the Court of Appeal first. And we'll go to the appellate committee afterwards. If we can just, again, take the facts from the head note. Starting right at the top, guidance in the code issued by the Health Secretary under the Mental Health Act 1983. The subject matter was the use of seclusion for detained psychiatric patients. And we can see a summary of what the code included at letter F. And the facts of Mr. M's case are then set out. We can see that one of the points raised was that the hospital's seclusion procedure departed from the code in a number of ways. Can you just see that by letter G? And then the facts of S's case are over the page. And if I could ask you to keep going to page 20, paragraph 3. And we see there that that notes the guidance relating to seclusion in the Code of Practice was statutory guidance. And then a little bit further down, just above H, hospitals should observe it unless they had a good reason for departing from it in relation to an individual patient or a group of patients. And then if we go to paragraph 5, which starts at the bottom of the page and goes over, you can see that in Mr. M's case, the Court of Appeal held that the seclusion under the hospital policy was unlawful because there were no good reasons for departing from the code. And then S's appeal is addressed after that. Could we go, please, into the judgment of Lady Justice Hale, as she then was? Could I ask you, please, to start on page 58, and it's paragraph 73. My Lords, will see the heading further up that page, that this paragraph is in the section addressing the status of the Code of Practice. And paragraph 73, the second and more difficult issue is the weight which those to whom the code is addressed must give to its contents. Code is prepared for the guidance of doctors and others. My Lords, the next bit is important. No statutory obligation in the 1983 Act to observe it or to give reasons for departing from it. Therefore, no express statutory obligation upon anyone other than social services. And she then refers to a different statute, which is Section 7 of the Local Authority Social Services Act 1970, under which social services do have an obligation to act under the general guidance given by the Secretary of State. And she refers to the judgment of Mr. Justice Sedley, as he then was in Rixon, where he held that this meant that local authorities could only depart from the Secretary of State's guidance with good reason. She then describes what the first instance judges in that case did. They proceeded on the basis that, having considered the code, a hospital was free not to follow it unless to do so would be Wednesbury perverse. Now, my Lords, that is the submission that the respondents are making before you in their respondent's notice. They are saying what was essentially found by those two first instance judges, that the standard is Wednesbury, not good reason. The paragraph continues, there is a considerable difference between this approach and the Rixon approach, in which the code should be followed unless there is a good reason to the contrary. And you can see that she makes 2 points in the following analysis. She says, first of all, the fact that it would be contrary to the purpose of the code if hospitals were free not to follow it without good reason. And she says, secondly, and this is near letter C, that where human rights are engaged, the arguments for according the code greater status are compelling. And then she says in paragraph 76 that the code should be observed by all hospitals unless they have a good reason for departing from it in relation to an individual patient. So the approach followed by the first instance judges, that is of Wednesbury being the appropriate standard, was rejected by the Court of Appeal. If we can then go to the appellate committee in Munjaz, which is same bundle tab 5, and it starts at page 151. Just invite you to see the outcome on page 152. And then note paragraph 2 in between letters C and E. Code did not have the binding force of legislation and was guidance rather than instruction, not mere advice, and should not be departed from without cogent reasons, which should be critically scrutinized by the court. And then the remainder is applying that on the facts of that case. My Lord, could I ask you to go to the speech of Lord Bingham, paragraph 20 on page 191. Now, you might recall that at the outset, when I was giving you my propositions, I cited Munjaz, paras 21 and 69. I want you to see 20, though, because it explains 21. And 20 is a summary of the parties' arguments. So you can see that it begins with the question, if then the code is issued under section 1181, what is its legal effect in relation to those to whom it is addressed? And then there are, first of all, the submissions of the trust. And you can see the trust saying its guidance, it describes itself as guidance, difference between guidance and instruction, and that there is no statutory obligation to comply with it. You can see that at G. No express obligation was placed on the hospitals to follow the guidance. And then you see the arguments made by Mr. Munjaz. And he said that there were three things that were important. So first of all, the consultation which preceded the drawing up of the code. Secondly, the parliamentary sanction it received, because it was issued by the Health Secretary. And the third was the high importance of protecting detained mental patients. So those were the three factors that Mr. Munjaz relied on, and he said that they, and you can see this submission at the very end of the page, show that the code was intended to be very much more than advice which hospital authorities might choose to follow or not to follow. And then over the page we have paragraph 21, where Lord Bingham says that the code does not have the binding effect which a statutory provision or statutory instrument would have. It is what it purports to be, guidance, not instruction. But the matters relied on by Mr. Munjaz show that the guidance should be given great weight. Much more than mere advice, which an addressee is free to follow or not as it chooses, should be considered with great care, and from which it should only depart if it has cogent reasons. And then right at the end of that paragraph, in reviewing any challenge to a departure from the code, the court should scrutinise the reasons given by the hospital for departure with the intensity which the importance and sensitivity of the subject matter requires. And then can I just show you paragraph 69, Lord Hope. And that's page 207. And you can see there that he agrees with Lord Bingham, and the clearly, logically and convincing comes from this paragraph. But of course, as my lords will know, that is just the meaning of cogent anyway. So all he's doing is unpacking the components of the word cogent, the clear, the logical, and the convincing. And then he goes on to refer to Parliament's expectation that the code would be followed unless there are cogent reasons for not doing so. But just pausing there, my lords, and just taking stock of what those two paragraphs show us, in our submission, what they show is that the analytical search that this court is also embarking on in this case is for factors that show that the policy in question is intended to be more than advisory. And where that line is crossed, where the court concludes that this is something that is more than advice, that is where the need for cogent reasons and judicial scrutiny is engaged. Now, going back to nuance and the importance of nuance, and as I've said several times, I entirely accept that the intensity of the scrutiny, it may be more or less intense, depending on the subject matter. But the critical point is, you do need the cogent reasons. And Lord Hope's reference that I've just shown you to Parliament, that in our submission is not restricting the statement of principle to cases where Parliament has such an expectation. That is the factual basis in that case for finding that the policy was intended to be more than advice. So it was one of the factors in the analytical search. It is not a requirement. And so we say that it's clear from Munjaz that the standard of review is of cogent reason. And just two final points on Munjaz. The difference in approach between good reason and Wensbury that is identified by both the Court of Appeal and the Appellate Committee, we say, is important. And the reason for that is in Nadaraja itself. And I just want to now show you, I said I would show you a bit of Nadaraja. I want to show you why I say that difference is important. If we could go to tab 1, this is in bundle 1. It starts, sorry, bundle 1, tab 3, starts at page 65, and could I ask you please to have a look at paragraph 68, which is on page 97. My Lords will see at the start of paragraph 68 the proposition which I've already given you, and we've seen it in Hamati. But it's the bit which begins, what is the principle behind this proposition, that I want you just to look at, please. It is not far to seek. It is said to be grounded in fairness and no doubt in general terms. That is so. I would prefer to express it rather more broadly as a requirement of good administration, by which public bodies ought to deal straightforwardly and consistently with the public. In my judgment, this is a legal standard which, although not found in terms in the ECHR, takes its place alongside such rights as fair trial and no punishment without law. He then goes on to say that there is every reason to articulate the limits of this requirement, and he says a public body's promise or practice as to future conduct may only be denied, and thus the standard I have expressed may only be departed from in circumstances where to do so is the public body's legal duty, or is otherwise, to use a now familiar vocabulary, a proportionate response. And then at the end of that paragraph, the principle that good administration requires public authorities to be held to their promises would be undermined if the law did not insist that any failure or refusal to comply is objectively justified as a proportionate measure in the circumstances. So that was the first point in terms of explaining why that difference in approach is important and principled. And the second is that these passages that I've just shown you show why the respondent's notice and the related submissions are unmeritorious. And in their skeleton, at paragraph 14, the respondent says that the appellant, and indeed the judge, are elevating a fact-sensitive decision into a general principle. We submit that is an impossible reading of the passages that you've just been shown. It's obviously right that good reasons is a fact-sensitive analysis. You saw that from paragraphs 20 and 21 of Lord Bingham's speech, and that's a point that we expressly rely on. It's in our skeleton, for example, at 36.3. But the fact that the application of good reason is fact-sensitive does not mean that we are in the territory of rationality. And the same paragraph in the respondent's skeleton argument also says, oh, well, Munjaz is concerned with a policy under a statute, and so it's different. But again, there is nothing in the paragraphs that I have shown you that suggests that the point of principle is limited to where the policy has that statutory imprimatur. And that is no doubt because there is no coherent reason, we submit, to limit the principle in that way, especially when one recalls the underlying point that I've just shown you in Nadaraja, it would be absurd to suggest that the requirement of good administration is engaged only in cases of statutory guidance. So Munjaz is obviously the key authority since it's Supreme Court, but can I also show you briefly Tower Hamlets, which is 2013, and this is again on standard of review being good reason, but it's also authority for the proposition that the greater the departure from the policy, the more compelling the reason must be. It's Bundle 1, Tab 10, page 419. And this is a policy under the statute that I showed you in Lady Justice Hale's judgment in Munjaz. You recall she referred to Section 7 of the 1970 statute when she was talking about statutory obligations. And so that is the provision which this case is concerned with. You can see that on page 419 between letters F and G. And if you go over the page to 420, between C and D, you can see that it was a judicial review claim. It was said that the local authorities' policies were unlawful. And part of the local authorities' response was that if the policies were contrary to the statutory guidance, then there were cogent reasons for departing from it. That's just above letter E. And then at the bottom of the page at letter J, you can see that the court found that the local authority had not discharged the burden of showing sufficiently cogent reasons. And then if we turn on to page 429, if you look at paragraph 27 under the heading Status of the Guidance, you'll see that Mr. Justice Mayles, as he then was, he describes the legal status of that guidance. Under 1970, refers again to Rickson, and then he refers to Munjaz, and he says that although Munjaz addressed a different statute, what was said by Lord Bingham and Lord Hale applies equally to guidance issued under the 1970 Act. Now, I'm showing you that because it's an important passage in responding to the point that's made by the respondent, oh, well, you can't get anything from these two cases because they're statutory guidance cases. What we see here is the observation that the statutes were different. And the distinction is, as we saw again in Munjaz, that the guidance did not expressly oblige the hospital to comply, where the statute did not require the hospital to comply with the guidance. And the guidance under the 1970 Act is distinct because it did. And the point is, again, that that wasn't something that changed the approach. It was one of the factors that went into that analytical search that I say the court is embarked upon in those cases and indeed in this case. And so if I could then ask you to look at the key paragraph, which is 35, on page 430, you will see that he says there, departure from the guidance will be unlawful unless there's a cogent reason for it. And the greater the departure, the more compelling must that reason be. The next case is HZ, which is Bundle 2, tab 28, and it's page 1047. So this involved, we can see from the head note, a challenge to the defendant's decision to offer two claimants temporary accommodation in Manchester rather than London. You can see the grounds of challenge from page 6 on, paragraph 6 on page 1051. And one of them, you'll see in little Roman 2, was that the defendant had failed to follow policy. And if we turn on, the relevant principles start at paragraph 104 on page 1084. And it is in that section that we find the passage that we rely on, which is on page 1086, para 107. And it's that last sentence in particular. Certainty with which a policy is expressed may be relevant to the questions of whether the defendant has in fact departed from it, and if so, whether or not there was good reason to do so. Now, my lords, that's cited by the respondents as well. It's in their skeleton at paragraph 13. And they cite it in support of the assertion that the context, nature, and terms of the policy will affect what needs to be shown by good reason. They then later in their skeleton at paragraph 26 make a submission where they say, and I quote, where there is no dispute that D is entitled in law to depart from the terms of reference, and it goes on, it is impossible to understand the assertion, they say in our skeleton at para 34, that there was a legal error in the judge accepting that D had a discretion to depart from the terms of reference. Now, I will deal later with interpretation, but can I just make 2 points on that submission in the respondent skeleton now? First of all, the appellant submits that the judge erred in his construction or interpretation of the terms of reference insofar as he held that the terms of reference themselves or itself gives RAVC the discretion. We say that is an error of interpretation, because properly interpreted, when you look at that document, it does not contain, even when put into context, that discretion. But second, it is of course common ground that RAVC is entitled in law, in general, to depart from the terms of reference. But the reason why that interpretive exercise matters is, as I've said, the terms of the policy are going to influence what is to be regarded as a good reason. Because as we've seen in both Tower Hamlets and now in HZ, that the certainty with which the policy is expressed is relevant to whether or not there's a good reason for the departure. And as we saw in Tower Hamlets, the greater the departure, the greater the need for there to be reasoning explaining it. So it's not good enough just to say, well, we all agree that you can depart from a policy, so why do we need to spend all this time looking at what the policy means? Why can't we just go straight to whether or not there was a good reason? The reason is that analysis of whether or not there is cogent reasoning supporting the departure has got to be assessed by reference to the certainty of the policy and what it says and what it means. Begum is the next one, and my lords, this relates to the second proposition in the sense that it is relied on by the respondent in support of the proposition that the standard of review is Wensbury. And we submit that the respondent's reliance is based on a complete misreading of the judgment. Since it is one of the respondent's cases, other than flag for you that we have made our points on Begum in the skeleton at paragraphs 53 to 62, I'm not going to turn to it in opening. I will deal with it in reply if I have to. The court has our submissions in those passages. And so the last authority to show you is Carlyle. And this is about weight or deference. It's Authorities Bundle 1, tab 13, page 488. And of course, the facts are very far removed from the present case. It's relevant, though, because it addresses the role of the court when considering the proportionality of executive decisions. Now, this was in the Human Rights Act context, but there is, of course, some overlap. And as we've seen, proportionality is part of the court's analysis when it considers whether there is a good reason to depart. You recall I showed you that passage from paragraph 68 of Nadaraja making that point. So this is relevant for those reasons. And if I just invite you to look at the head note on page 488, although proportionality was ultimately a matter for the court, that did not entitle it to substitute its own decision for that of the primary decision-maker, or simply to frank the decision without itself considering it. But the degree of restraint to be exercised by the court and the extent to which the assessment of the primary decision-maker would be respected depended on the context. And then it goes on to... I should just read the next bit as well. Where the decision was based on factors where the court did not have the evidence, experience and institutional legitimacy to form its own view with confidence, its interference could only be justified in exceptional circumstances. The reason I just wanted to read that out is I will be saying to you that you do have evidence in this case. That is one of the relevant points. And then just show you paragraph 22 in Lord Presumption's judgment, which is on page 508. And it's the bit around letter B. In some circumstances, deference is no more than a recognition that a court of review does not usurp the function of the decision-maker, even when convention rights are engaged. Beyond that elementary principle, the assignment of weight to the decision-maker's judgment has nothing to do with deference in the ordinary sense of the term. It has two distinct sources. The first is the constitutional principle of the separation of powers, and the second is no more than a pragmatic view about the evidential value of certain judgments of the executive, whose force will vary according to the subject matter. He then refers to Lord Hoffman's speech in Rahman and quotes from it. And if we go over the page, page 509, and it's paragraph 54 of the quotation, you can see there that Lord Hoffman says it does not mean that the whole decision on whether deportation would be in the interests of national security is surrendered. And then 4 or 5 lines down, the factual basis for the executive's opinion that deportation would be in the interests of national security must be established by evidence. Again, that is something that I will be coming back to, because what you have in this case is RAVC's opinion that the bespoke process is better than the RMB. And that is obviously something that you're going to be looking at to see whether or not the reasoning given is clear, logical and convincing. And one of the ways in my submission that you're going to want to do that is by looking at their own evidence, which you're perfectly entitled to do, as these cases show. And then just one more quotation from Lord Hoffman, which is on the evidential issue, and it is also, I think, at paragraph 24. I've just lost my note. Just give me one moment. Actually, my lords, I don't think I need to show you that, so I'm going to move on. And I want to just end the legal section with this. The fact-sensitive approach that we've seen in a number of these cases is consistent with the approach regularly taken by courts when they have looked at the facts and they have rejected attempts by the government to invoke some absolutist deference principle in contexts where the court is the ultimate arbiter. And there are 2 examples in the bundle, which I may come back to in reply, but I just invite you to note them for now. The first one is Rwanda in the Supreme Court, and that's Authorities Bundle 2, tab 27, page 999. And the question in that case, as my lords may recall, was whether there was a real risk of refoulement, which was a matter, just like whether there's a good reason to depart from a policy, for the court to assess And I just invite you to note paras 51 to 52 of the Supreme Court's judgment, which is page 1019. In essence, the court was required to make its own assessment, attaching appropriate weight to the government's view, and then also paras 55, 6, and 7. And then the other illustration you have is the Attorney General and BBC case, which is Authorities 2, tab 25, page 969, and it's paragraph 29 that's relevant there. As I say, I may come back to those in reply, but they make the point which
Can you give me that reference again?
AG and BBC, it's paragraph 29, it's Authorities 2, tab 25, page 969. So they make the point that is already made by Carlyle about the extent of the weight or deference that may be appropriate, and not to assume that it has the sort of general application that the government often claims that it does have. My Lords, on the respondent's notice, I've already addressed the case law at some length, but can I just make 3 short concluding submissions on it? First of all, Munjaz is obviously binding on this court, and we say that it makes it very clear that the test is not Wednesbury rationality. The second point is that the respondent has not identified a single authority which supports its position, and the judge noted that in the judgment at para 157, and I've already addressed their purported reliance on Begum, which they're misreading. And then the third and final point is, as I have said throughout showing you the cases, that the invocation of constitutional principle and concerns about democratic accountability in particular are not engaged here. The respondent's position appears to be that whenever there's a discretion, and if convention rights are not engaged directly, then you're in the territory of rationality because of the principles of democratic accountability and institutional expertise. And they say in their skeleton at para 15, and I quote, "Any other approach would require the court to substitute its own judgment on the merits for that of the constitutionally accountable and institutionally competent decision maker." And we say that's a very, very far-reaching submission, and one that sits uncomfortably with the fact that there are many contexts where this court will be required to consider whether the executive has satisfied a particular standard on a more hard-edged basis than rationality. Obviously, good reason is one, legitimate expectation is another. That doesn't mean, as I have now said a few times, that consideration and appropriate respect won't be given to the expertise of the decision maker. But the good reason threshold has still got to be looked at on the facts to see whether or not cogent reasons have been given. And we say that that provides an answer to the respondent's submission that a rationality standard is required because it has built into it the ability to take into account a spectrum of contexts. That is what they say in their skeleton at paragraph 15. That's not a good explanation because obviously good reason has exactly the same sort of fact-sensitive spectrum built into it. And then they say finally at paragraph 16, well, we all understand what a rationality review entails, so we should apply it for that reason. And we say, well, we know what the cogency test involves. I've just shown you that. That is also clear and well established. And the problem, and in our submission, the reason why the Wednesbury review test is being pressed on you is because the respondents cannot satisfy good reason. They cannot satisfy cogency, and that is why they are submitting that the Wednesbury test is the one that's applicable. Now, with that, can I turn, somewhat later than I had hoped, to ground 1A and interpretation? Now, can I give you the key paragraphs in the judgment that I'm going to be addressing? 158, 159, 162.
Sorry, I wasn't ready for that. 158.
159,
Yeah.
162, 175, and 176. Those are the key paragraphs. Now, in terms of the structure of my submissions, what I want to do is just introduce the key documents, and I may be able to take this quickly if the court is familiar with them. I just want to make sure that you have seen the parts that I want to show you. And then I'm going to flag, as I've been saying, the purpose, content, and context that we say the court should be looking at when doing that interpretation exercise. And I then want to make submissions on what we say are 3 interpretive errors that were made by the judge. In terms of the documents, if I can start there, obviously the court will have the fact that the most important document in this case is the 2017 terms of reference. That was in place when the February 2020 decision was made. And Sir Richard Mottram says that the 2017 version, although less detailed than the 2021 version, does not differ in any significant way in terms of the role of RAVC and its approach to its remit. That's Mottram 1, para 10, supplementary bundle, tab 2, page 37.
And as an electronic reference for that. I mean, if you can give me electronic
I think it
reference.
is. I think it's 37. So the page number I give you should always be the electronic reference.
In the supplemental or core?
Supplemental, and it's tab 2.
37.
Supplemental, page 37.
Okay, thank you.
And my lords know that RAVC has made decisions about the appellant since 2021, and so we submit that although the focus of your analysis is obviously on the 2017 terms of reference, the 2021 terms of reference are plainly relevant in informing your analysis regarding the decision-making process. Both of the terms of reference...
I thought we were only concerned with the decision of the 28th of February 2020.
My lord, that's correct, but I think it's accepted on both sides that if that's unlawful, then that's going to influence the decisions that were subsequently taken as well. So I don't understand that any point is taken by the respondents as to the fact that there were different terms of reference in play from 2021 onwards.
I don't see, speaking for myself, how the later terms of reference can help us as to whether the 28th of February 2020 decision was lawful or not.
Well, my lord, it helps in my submission because you're looking at RAVC's process.
Looking at RAVC's what?
RAVC's process.
Process.
Yes, it's the decision-making process.
Yes.
That process is in the 2017 terms of reference. I'm going to give you references to that document. All I'm saying is the 2021 document is relevant, and Sir Richard himself has said that there isn't a significant difference. And the only reason I'm asking you to even look at the 2021 document is it has more detail, and that detail is helpful in understanding that process. And although there are some things that are different, for example, in 2017 it was the chair that took the decisions, in 2021 it's the committee. Yeah. As far as I am aware, there is no material significance in terms of the role of the RMB, and that is obviously the critical issue for us on this appeal. And that is the reference I've given you to Sir Richard's first statement at paragraph 10. So I'm inviting you to look at 2021 to fill in some of the colour that we don't have from 2017. Both of the terms of reference are written or reviewed by RAVC on an annual basis. And my lords, if it's convenient, could I just give you the references without asking you to turn them up? And if it's convenient, I will give them, first of all, to the 2017 terms of reference and then to 2021, just so you know the order. So that's paragraph 24 of 2017 and paragraph 45 of 2021. So those are the two terms of reference documents. There is also a document which has been referred to as the EC. or the evaluation criteria. That is also a 2021 document. The judge said that caution is needed in using this to determine if the 2020 decision is unlawful. That's in the judgment at para 163. But again, there has been no suggestion from RAVC that the EC contain any different approach vis-à-vis the matters with which this claim is concerned, namely the role and significance of the RMB and of the RMB's assessment in RAVC's decision-making process. Now, those EC documents, as I will call them, they are required by and referred to in the 2021 terms of reference. And you'll see that in para 6, bullet point 7. So the document, the EC, it's part of RAVC's policy framework, and Mr. Hipgrave has said that the EC is intended to ensure decisions are taken in a consistent and transparent manner, and that RAVC has employed it. That is the EC. So again, anticipating what my Lord may ask me in terms of its relevance, it has the same role in my submission, which is to provide some colour for when you're looking at RAVC's process in 2017, certainly, because that is the relevant document for the 2020 decision. But as I say, I do not understand it to be said that the RMB's role or the role of its assessment changed between 2020 and 2021. And if that is a point taken against me, then I will reply to it. I am not aware of that being a point. Now, the court may have seen that when this claim started in 2021, the only terms of reference that the appellant was aware of is the one from 2008. I just want to make sure that you've seen that. It is in the bundle, supplementary 10, page 167.
Very short.
It's very short. Precisely so, my Lord. And that is significant. One sees the evolution of the document in the intervening almost decade. And we know why the document evolved, because we know that there were two reports that were produced for RAVC, the Tesh Review and a report by the College of Policing, and we see the significance of their input into the terms of reference. Why does that matter? It matters because it shows that this is not a merely advisory document. It is far greater significance than that, because you can see that RAVC itself was, in my submission, taking on board the views of undoubtedly experts to inform what it was doing. And we will say in due course that that is similar to the consultation that you saw in Munjaz, which led to the code. The consideration of the content in a careful way. Now, I want to go through each of purpose, content, and context. I hope I can do the first two quickly, because it's just by reference to the documents themselves. The purpose of the terms of reference is to set out who RAVC is, what it does, and the process that it follows to make decisions. And we see that from para 6 and para 20 of the 2017 document, and paras 2, 6, and 7 of the 21 document. And in terms,
I find that very helpful without going to the document.
my Lord, I'm very happy to take you to that. What I was going to suggest, but I see that my Lord Master of the Rolls is working only electronically. The most helpful thing to do is to have them both side by side, which you're not going to be able to do. There's a little bit of flicking backwards and forwards otherwise. I don't...
Just explain why the 21 makes any difference. I mean, perhaps naively, I thought that you relied on the sort of mandatory nature of the requirements for A and B.
Yes. That
Which is actually the same.
It's exactly the same, precisely so. Why do I rely on the 2021? It's because of the EC. Yeah. That document is part of the 2021 terms of reference.
Yep.
Why do I rely on the EC? The EC tells us why we need the RMB. You don't get that purely from the face of the 2017 terms of reference in the same way. You get some information.
Can we look at it?
The evaluation criteria, my lord.
Yes.
Yes, of course. It's page 173. Well, there are a number of paragraphs that I want to show you about this, but perhaps the most critical, if you go to paragraph 5 on page 174, the 2016 TESH review is currently the key document underpinning the principle that RAVC should make decisions based on an evaluation of the risk analysis conducted by the RMB. TESH differentiates between analysis and evaluation in the following way. And you can see there's a quotation from paragraph 16 of the TESH review. And what John Tesh said is that the best risk management processes encompass but make clear a distinction between, and then you'll see that there are two things. So first of all, you have risk analysis, and the next paragraph, you have risk evaluation. Now, risk analysis is described as an objective, dispassionate inventory of what the risks are, including what would have to be reckoned with in terms of the impact and what the associated likelihood is. Now, pausing there, that's what the RMB does. We then see risk evaluation. That's a policy-making process in which social values and risk tolerance levels are factored in by ministers and officials in order to decide about the objectives of policy, what measures can or must be taken to achieve those objectives, and whether the residual risk is tolerable. That is what RAVC does.
Yeah.
And then if you, since we're in this, perhaps I should just show you a few more of the passages. You can see in paragraph 8, well, standing back, I should say, what they're doing in 6, 7, and 8 is explaining, essentially, that they need to develop the risk evaluation framework. So the bit that RAVC does, they're trying to develop in this document, not the bit that the RMB does. And they're explaining in paragraph 8 why that framework would help. So you can see, to ensure that decision-making processes are applied consistently across the cohort of protected principles, ensuring that different factors are not weighted disproportionately in relation to different principles. It will also strengthen the transparency. And then you have the heading criteria for evaluation, where they then go on to explore that very thing. And you can see that they say, worth exploring each of the criteria for evaluation set out in TESH. And my lords, this sentence, which understandably I put great emphasis on, the description of the RMB, crucial to that consideration, that is, of what should be in the criteria for evaluation, crucial to that consideration is the parallel review of the RMB.
When did that take place?
When did...
The review. You referred to TESH.
Yes.
And it was 2016?
It was 2016. I don't believe that we know the date of the RMB review. You can see that it's described in some more detail later on in that paragraph. I'm obviously not going to continue reading out, but you'll see...
What I was puzzled by is paragraph 8, which says developing such a framework, obviously in the future, should also help assure committee members that decision-making processes are applied consistently, etc.
Yes.
So, I mean, this is all forward-looking, is it not?
Yes, it is, as far as risk evaluation is concerned.
Yeah.
But we're not. But my lords, I'm not troubled by that, because I'm not asking you to look at how RAVC itself has evaluated the protective security. That is not part of my challenge. My challenge is the process that RAVC followed before that. Because what you see in the terms of reference is that RAVC's risk evaluation has got to be based on the RMB's risk analysis. It's got to be based on it. They're not done side by side. One is not done as an advisory, oh, well, if you want to ask the RMB, then by all means do. No. It is a principle, that's how they describe it themselves, that came from the Tesh review. And that's why when the judge criticised my referring to the words in the document, the will, we'll see that in the key tasks, the executive committee will, and then refer to getting the report from the RMB, it's not just a fixation on the language, it's because we have a rationale. And the rationale is not just that the RMB is a distinct body with distinct expertise, but it's doing something different. And that's why I say this document matters, because it supplies us with the rationale.
It analyses and supplies detail as to the risk in broad terms. So without them, you don't know what the level and nature and a lot of other things about the risk. Correct?
Yes, in the objective, dispassionate inventory.
What I think will be said against you is that the decision RAVC was making in this case was what was the consequence of the claimant stepping back from royal duties and going to live primarily abroad, as regards further protection being provided by Her Majesty's government for him when he came to England. And that is not affected, on one analysis, I think it's said, by the absolute level of risk or the nature of the risk, because what they say, as I understand it, is there was put in place a process that whenever he announced his intention to come to the UK, some evaluation would be made of what for and where and why and how, and then risk might be relevant, but this was a decision as to the principle of whether, I'm going to use the wrong language, but blanket security should be provided when he was overseas under the RAVC process.
Yes, that point.
And therefore it said, well, we're confusing apples and pears. The level of the risk is obviously critical when you come to consider what kind of security you're going to provide and the type of risk and so on. But this wasn't the question they were deciding. They were simply deciding whether he was within their cohort, and that's something for them.
It's not for them,
right,
in my submission. The terms of reference, and we've slightly digressed away from the structure that I was following, but the terms of reference, the reason why it's so important to look at them is they identify who is in the cohort. Can I just say, the word cohort is really apt to mislead.
It's apt to mislead, but I won't use it again.
Well, I say that, my lord, because if you look at the submissions and the evidence, it is used a lot. But it is not always clear what it means by the person who's using it. So I'm going to try and be more precise and not use that word cohort. Well, I'm going to say who is within RAVC's remit.
Right.
Okay, that's the first question, and the answer is members of royalty and public figures. And I said this to Mr. Justice Lane. I am not within RAVC's remit. Clearly. It's got to be someone who comes within that description. And we have evidence, and I will take you to it in the closed session, about what that means. So that's how you get... That's not about you. It's not controversial to say that the claimant is within the remit of RAVC, is it? Well, it shouldn't be.
Stepping back from royal duty.
Well, Precisely so. That's my point, my lord.
Well, they say that it's within their remit because they say they're going to consider what they should do whenever it comes to the UK.
Exactly. This is not a case where the appellant has been knocking on their door saying, let me in. They have let him in. So that is the remit question. Once you're in their remit, the terms of reference say that there are two questions for RAVC.
Yes.
One is whether that person gets protective security. So being in the remit doesn't mean that you get it. They still will consider whether or not you should.
Yes.
And then they will consider, if you're going to get it, what you should get. So all of that has got to be considered. Now, going back to my lord's point about the point that will be taken against me, so Richard's evidence is that when there was the change of role from full-time working member to not being a full-time working member,
Yes.
his evidence is, well, the terms of reference don't apply to the appellant. We don't have to make our decisions under the terms of reference. And that's paragraph 14 of Mottram 1. Now, that in my submission is wrong. You cannot do that as RAVC. He is obviously within your remit. He is a member of the royal family. You have accepted that he is within your remit because you are considering his case.
Give me the page reference for SRM. I'm calling him SRM 1, paragraph 14.
If you can give me one moment, because I've
Supplemental bundle, page 38.
stepped away. Thank you very much.
This is a non-confidential paragraph, is it?
Yes, it is. And it is... perhaps if I can just show you from the top of that page, he describes the essence of implementing the policy. That's the government's national risk assessment policy. And then he explains that there are two guiding principles. You see what they are.
Sorry, I'm not seeing two guiding principles.
So
Paragraph.
this is paragraph 14, but it continues on page 39. I thought...
Sorry, I'm in the wrong place. I was confusing pages for paragraph.
not at all, my lord. So it's page 39.
Yeah, got it.
And he says at the top of that page, he refers, you can see, to the government's national risk assessment. And he says the essence of implementing this policy in the area of protective security was that, and then there's the first guiding principle, which is essentially where risk is sufficiently significant in terms of likelihood and impact on the interests of the state. And secondly, proportionate protective security measures should be provided at public expense appropriately to mitigate that risk. He then says, within these guiding principles, it was for RAVC to determine which individuals were within the cohort, and you see what I mean about the use of that word, for which it took responsibility for the provision of proportionate security measures. And this cohort changed over time as the roles of individuals changed and as security threats evolved. Just pause
in
it.
that sentence, cohort means the people who satisfy 1 and 2.
Exactly.
Yes.
Exactly.
Right.
But sometimes it's not used in that way.
No, well, it is here.
Yes, and this is part of the problem. But anyway, moving on, he says, it follows that RAVC did not produce nor was governed by a form of overarching guiding policy document which sets out who is to form the cohort and in what circumstances. There was no such document. Now, I accept that, of course. But what that means is when RAVC's considering the whether and the what, the evaluation bit that we saw, there isn't something which explains in detail how it's going to do that. We have the guidance in the evaluation criteria, but we don't have a document setting it out chapter and verse.
Right.
And then he goes on. I and the members of RAVC followed the guiding principles as set out above and reached decisions in individual cases in a flexible and context-sensitive manner accordingly, including by reference to how potentially analogous cases had been handled in the past. and this is the important bit, my lord, when the claimant refers to RAVC's policy, it must be understood in this light. In particular, I should note that the 2017 terms of reference do not specifically address the responsibilities of RAVC in relation to an individual whose status has changed and no longer falls within the cohort of principles. That is clearly a matter for RAVC, but it is not a matter guided by the 2017 terms of reference. So what he's saying...
So do you disagree with that?
I say that's wrong.
Wrong in what sense? It's
That's
evidence.
not what the terms of reference say, and it's not what, in my submission, properly interpreted the terms of reference mean. What they mean, as I've said, is if you're within the remit, RAVC has got to comply with those terms of reference. I mean, the name of the document is a clue. It's terms of reference for RAVC. It's explaining how RAVC needs to approach its decision-making. It is not saying...
Well, just pause for a moment. I completely see the sort of blanket nature of the submission that, terms of reference are terms of reference, and therefore what you do are guided by terms of reference. That's all very logical, if I may say so. But I think the problem here is this has never happened before. So there's not a part of the terms of reference which say what does RAVC do when a previously active member of the royal family undertaking state duties decides to step back and go and live abroad. There's not a section that says...
No, there is not.
What I understand Sir Richard to be saying here, and I may be wrong, is that actually there's no specific part of RAVC that addresses the responsibilities of status change, etc. So we were flying free in reaching a decision as to what to do. I think he's not saying we completely ignored terms of reference. He's just saying we didn't get specific guidance.
Well, my lord, I may be corrected by the respondent, but my common ground, you recall I began with this.
Yes.
As far as I understand it, it is common ground
Yes.
that Sir Richard did not consider that the 2017 terms of reference applied to the claimant. So...
Well, I think that's too broad a statement, isn't it? I mean, of course they applied to the claimant because they applied to everything the RAVC did. What he's saying is what he's saying is precisely in this sentence. In particular, I should note that the terms of reference do not specifically address the responsibilities of RAVC in relation to an individual whose status has changed and no longer falls within the cohort of principles. Now, I understand, but he's used that term here to mean people who are going to have protection.
Yes.
So let's assume he still means
Yes.
that. And that's clearly a matter for RAVC, but it's not a matter guided by the terms of reference. So that's what he means. He's not saying the terms of reference don't apply to the claimant, or he doesn't have to apply the terms of reference, or even that he didn't consider the terms of reference. He's just saying, in this particular decision, I don't get any specific help from the terms of reference, isn't it?
Well, my lord, I haven't understood the respondent to be interpreting it in that way.
Okay, all
But
right.
as I say, I may be corrected in that.
Well, I should be corrected if I'm wrong as well. Yes.
My lord, it would make things a lot easier if what my lord is saying was actually the position. Part of the reason I'm having to fight this is because of the way it's been defended, which is to say, we didn't apply this at all. You completely fell outside of the process. But can I just deal with this idea of flying free? And I will come back to it in the closed session. RAVC were not flying free.
No, of course not.
They
It's
were
a
not.
very bad expression.
No, it's very helpful, if I may say so, as a shorthand for this idea that essentially there wasn't a precedent. They were not flying free. And that's why this whole structure of how they approached it, what they were thinking about, how they explained themselves, we'll come on to the contemporaneous document, it matters. And so, my lord, going back to this point that you made to me about it will be said against you, well, this is all very interesting, but this was novel and unique and different. Yeah. In my submission, no. That there are guiding principles in these documents and in the practice of RAVC that show, as I said, that the bespoke is in fact different, unjustified and inferior. And we need to get into the detail.
The bespoke is what?
Different, unjustified and inferior.
Oh, I see. You mean this bespoke?
This bespoke, yes.
Yes.
May I just go back a little bit? Because what I was doing was just going through the 2 terms of reference documents and giving you some references. Can I just make sure that you've got them? And I'm mindful of the fact that my Lord wishes to see a specific document, so I don't want to skip over them. But can I show you in particular just 2 passages in both of them? So the 2017, this is in terms of what RAVC does, and it goes to my point about the will. So this is paragraph 20, and it's the 3rd bullet point. So it is page 171.
Yes.
So that's in terms of what RAVC does. Executive Committee will evaluate the risk analysis conducted by the RMB in order to, and then you get the who and the what. And the same provision is in the 2021 terms of reference. It's page 178. It's now paragraph 6, and it's now the 1st bullet point. And again, just to make good the point I've made about the remit, the remit is members of royalty and public figures who are present in England, Wales and Scotland. And again, if I can just show you the 2017 terms of reference, you see the word present on page 168 in para 3. And again, I hasten to add, I'm not saying it's just the words. I'll come back to give you the colour later. But we see present, and then in paragraph...
Sorry, you're going too quickly.
Page 168.
Yes, I'm on 168. I'm in paragraph 3.
Chair is responsible for decisions for individuals who are present in England, Wales and Scotland.
Right, yes.
And then if you go to page 171,
yes.
You can see there, paragraph 20, first bullet point, exercise the national policy.
Yes.
Again, that same members of royal family and public figures. And then if you go to the next page,
Yes.
172, if an individual who falls within the remit, that's why I've used that word.
So 172.
Paragraph 23.
23.
So those are just the passages to make good what I've said about who is in the remit. So it's member of royalty who is present in England, Wales and Scotland. And then we see...
What does that mean?
Which bit, my lord?
Present.
Here. They don't have to live here. They have to be here.
So what if they're not here most of the time? What does it mean, present? Does it mean present all the time, living here, mostly present? What does it mean?
Well, in my submission, it means enough for my purposes, which is it applies when the person is here. So this is...
Whenever the person is
Whenever the person is here. This is again my point about remit, the flying free. This is why the terms of reference don't exclude somebody who is in the appellant's position.
But they didn't, did they? I mean, I understand your point about different, unjustified and inferior, but they didn't exclude him, did they, because he was going to be abroad sometimes, or even to live abroad?
No, but this goes back to paragraph 14 of Richard Mottram's statement. This is the question my lord put to me. Well,
yes, no, I see that, but I'm not sure it does get back to paragraph 14. I mean, paragraph 14, anyway, look, I'm just speaking for myself.
I understand, my
First
lord.
impressions, but it seems to me to address the question of the decision they were taking about the claimant when he stepped back from royal duties.
Yes.
And he says, and I understand why he says, because I've read this thing in its whole, he says that didn't give him guidance as to how he was to deal with that particular question. I can see why you say, well, it sort of does, or it does, particularly as regards the RMB. I mean, I get the argument. But I think you may be overinterpreting his paragraph 14 if you say that it says he just figuratively threw the terms of reference away and didn't consider them, because the terms of reference are the whole thing. They're the only thing they've got to go by.
Yes.
And he said, but just for this particular question, I didn't have much help from it.
Yes, and I may go back to the grounds of resistance to show you how the respondent has put it, because as I say, yes, they have, as I understand it, put it in far more extreme terms, which is we didn't operate under the terms of reference for you, and it's linked to why they didn't do the RMB, because they say we didn't have to because we weren't operating under that. They obviously go on and have an explanation as well, but one of the defences is this just doesn't apply to you, this whole system just doesn't apply to you because you're not in the cohort, as they've put it. Can I just show you the passages in 2021 now, which start at 177?
Well, just before we do that, Ms. Fatima, can we go back to 2017, paragraph 3, which you were just showing us? Individuals who are present in England, Wales and Scotland.
Yes.
It seems to me, looking at that as written in 2017, nobody was thinking about the possibility that an individual clearly within, I'm calling it cohort, but clearly within the remit, might go and live abroad. And this covers individuals who are present in England, Wales and Scotland, special arrangements for Northern Ireland, and decisions on protective security for any overseas travel from the UK.
Yes.
There's something called the Royal and Ministerial Visits Committee.
Yes.
But there's nothing there about somebody within RAVC protection who goes to live abroad.
Which is why, my lords, I'm going to address you in the closed session about why I'm not saying, just look at this, don't look at anything else. I'm saying, look at this, and then let's look at everything else that goes around it. Because when you have all of that context, this means what it says. It means it's somebody who is present. And so I entirely take your point that looked at in a vacuum, that would not support the interpretation that I'm pressing on you. I'm not asking you to look at it in a vacuum. And I will come back to that word later.
Thank you.
Going back to 2021, and this is just on that remit point, we see it again, the phrase royalty and public figures in paragraph 1. This is page 177. It's in paragraph 2 as well, and then it's in paragraph 6, in the second bullet point. Now, the reason I've made this point in a bit of detail is because the judge criticised our approach. He said that if my construction of the terms of reference was right, then everybody present in England would be entitled to an RMB. That's how he put it, and that is in paragraph 168. And as I submitted before him, the remit point is the answer to why the construction of this document does not mean that everybody can knock on RAVC's door and say, do an RMB for me.
He may have been going too far. I think the point is the same if he was saying every public figure, because where do you stop with public figures? I mean,
well, this is what
everybody's a public figure in one sense. So,
well, you know, my lord, we have evidence.
If that's not true,
That's not. We have evidence.
There are thousands of people who might be.
They might be, but the reason that that isn't a good, I would say, answer to the remit point is we have some explanation of what public figures are in Mr. Hipgrave's statement. But that is besides the point, because nobody could dispute that the appellant is a member of royalty and therefore in the remit.
No, nobody disputes that.
The purpose of RAVC's policy objectives, just so that the court has those, are in paragraph 10 of the evaluation criteria document, which we were looking at earlier, but we didn't look at paragraph 10. Could I just invite you to make sure that you've seen that? It's page 175.
Yeah, objectives of the policy.
The objectives of the policy, and this goes partly to context for when you're looking at how to interpret not just the documents and how they applied them, but also when we come to good reason. So, responsibility of the Home Office to advise the committee of any relevant developments in these objectives, considered that they will likely to remain stable, must be done openly and transparently so that the committee always has a clear, predetermined policy framework. And this goes back to my Munjaz point. We're not in the territory of merely advisory, because RAVC itself is saying here that what it's trying to do is have clear, predetermined policy frameworks, i.e. something that has to be applied. And it then goes on to explain, again, my lords, critically in my submission, that in practice, and this is after having obtained an RMB assessment, RAVC should then simply have to test the recommendations of the RMB to ensure that they meet the committee's agreed objectives. So again, this isn't something that is a discretionary, voluntary phase that RAVC can choose to do or not do. We get very clearly from this document in particular that the role that this has. So, can I then, if you just give me a moment, I'm seeing whether or not in the question and answers I've covered some of this ground.
Well, sorry, I'm an friend of getting out of place. Can I just invite you to read the earlier part of that paragraph as well, its emphasis on flexibility?
Thank you. My lords, I think that's enough on purpose. Content, I think we've also covered. I've given you the references, I think, in both documents to the significance of the risk analysis done by the RMB. Can I just show you Annex A? Because I don't think we've looked at that. That is Annex A to the 2021 Terms of Reference, and it's at page 185. This addresses the process of RAVC decision-making outside the regular meeting cycle. And I want to show you this just so you can see paragraph 1, which is that, again, the starting point, even for these ad hoc meetings, is to have an RMB risk analysis. Yes.
So in terms of context, I said there were 4 strands. Can I just tell you what they are before lunch? The 4 strands are, first of all, the subject matter of the decision-making process. The second is the composition, role, and expertise of RAVC.
Sorry, say that again.
Composition, role, and expertise of RAVC. And the composition, role, and expertise of the RMB. The third is the nature of the information and analysis that RAVC gets when it's making decisions about who gets protective security. And the fourth is what we know about RMB risk assessments that have been done for other people and when. So those are the 4 strands, and if I may, I'll come back to those and then deal with the errors in judgment before going on to good reason. My Lord, I've been given a note, which is that my instructing solicitors have raised a concern that it might be difficult for those in the room to follow the references to the evidence. And so the proposal is that the open, that is to say redacted bundle, be provided to those that ask for it. And I'm told that they can liaise with the respondent solicitors, GLD, to see if that is possible.
Well, is that agreed? I mean, I'm not going to have arguments in open court about things that have not been discussed between the council.
My Lord, there is an open, that is to say...
I understand that the documents are not...
Yes.
I understand that the documents are not confidential within the confidentiality ring, but I would want to know that you have discussed with your...
I've just been given this, my Lord,
well,
so I raise it.
why don't you discuss it over lunch, and if it's agreed, of course, it's agreed. It's fine. But if not agreed, then we'll have to find a way of dealing with it, but not so as to disrupt
Certainly.
the valuable time in this hearing for the argument we're hearing. How are you doing time-wise?
I am behind where I should be.
And how are you going? Maybe you better discuss that with your...
I'm going to discuss that with Sir James and try and persuade him to give me some of his time.
Very good. Well, we will look forward to the outcome and see you all at 2 o'clock. Thank you.
Lords, I did not manage to persuade Sir James to give me any of his time.
Sorry, everybody was making a noise. Speak, say it again.
I did not manage to persuade Sir James to give me any of his time, but what he has agreed is I can use some of my time from tomorrow today with the permission of the court.
So what time do you expect to finish this afternoon?
3:30. I was supposed to finish at 2:30. I'm going to borrow an hour from tomorrow, so I'll go less tomorrow.
Right, okay.
Yes, tomorrow I would have had 1 hour for the closed session and 1 hour in total for reply. I'm going to take half of that time today, if that is something that the court is content for me to do.
Well, it's up to you, really. I mean, obviously, if Sir James doesn't take as much time as he thinks he will, then you may be able to buy a bit back.
Yes.
Okay, well, let's crack on as quickly as we can.
Thank you.
Try not to slow you down, Miss Butterworth.
Thank you. Context. I gave you the 4 strands.
Sorry, just wait until the doors stop banging. Thank you.
The first strand of context is the subject matter of the decision making. That is obviously the safety and security of those individuals that RAVC considers. That was recognised by the judge below at paragraph 157 and is consistent with what Lord Bingham had to say in Munjaz, which I showed you at paragraphs 20 and 21. The second strand was the composition, role and expertise of RAVC and the composition, role and expertise of the RMB. You've seen the composition and role of RAVC from the terms of reference, and we've seen that it is entrusted with the expertise to make the risk evaluation decision once it has received the RMB. As for the RMB itself, I've obviously shown you their role. In terms of the composition of the RMB, that is set out in Mr. Hipgrave's first witness statement at paragraph 56, which is supplementary page 92, or supplementary tab 4, page 92 for those in the hard copy. I'm not going to ask you to have a look at that now, but that is where he describes who sits on the RMB, which I will come back to later. And in terms of the expertise of the RMB, his evidence describes the RMB as providing RAVC with, and I'm quoting now from paragraph 54 of Hipgrave 1, expert advice in respect of the threat picture, the risks faced, and any proposed mitigation of those risks. So that's supplementary pages 91 to 92. There is no suggestion in any of RAVC's documents or evidence that RAVC has the same expertise as the RMB. Indeed, the whole thrust of the Tesh review recommendations, as reflected in the EC which I showed you, is that the RMB has different expertise from RAVC, and that is why there is that staggered approach of getting them to do the assessment before RAVC does the evaluation.
There's some membership overlap, I think.
There is some membership overlap, but it's difficult to know from what we've been told.
Okay.
The bodies represented are the same. RAVC seems to have people at a more senior level.
Yes, up to a point that the same bodies are represented, but it's the additional people that are on the RMB, which Mr. Hipgrave identifies,
Right.
which I will come back to.
All right.
And obviously the court will have the point that representation of the same bodies doesn't imply that those individuals have the same expertise, even though they are part of the same bodies. The third strand is the nature of the information and analysis that RAVC gets when making decisions. And here we know that the RMB considers threat, So that's Mr. Hipgrave's first statement, paragraph 61. And we also know that this is different from what is contained in the threat assessments, because what the RMB is doing is getting those documents and analysing them. And we get that from Mr. Hipgrave's first statement, paragraph 57, where he says that the RMB gets the threat assessments. It's not their job to, as he puts it, and I'm quoting, question or second guess the assessment level, end quotation. Instead, what he does, or it's what the RMB does, is analyse the information to, and I quote again, reach an overall view of the threat potential, with that being, he says, a judgment and evaluative exercise rather than a mechanistic one. Now, the reason I mention all of this, and those quotes were from paragraph 61, is we'll come back to the difference in the closed session in detail between what the RMB does and what the so-called bespoke process involves. But what you can see from Mr. Hipgrave's first statement, paragraphs 57 and 61, is it's not just the information that matters, it's who is analysing it. Because under the RMB process, the RMB is analysing it. We know now, under the bespoke process, that it's RAVC that's analysing it. And that's a point that I will return to. Mr. Hipgrave also says, importantly, at paragraph 20 of his second statement, which is supplementary page 163, he says, and I quote, that the RMB analysis is qualitatively different from a threat assessment. So it's not enough just to have the threat assessment, because first of all you have the RMB's analysis, but then he's going on to say that that is itself qualitatively different. And in paragraph 31 of Mottram 2, which is supplementary page 152, he notes that the RMB process, and I quote, is focused on the wider issue of risk, not just threat. So this is all in the context of what is it that RAVC gets when it's going through the normal RMB process. So we know that RMB considers threat, and we know what it's bringing to the table when it's considering threat. It's the analysis, and it's the qualitative difference in that analysis. The second thing the RMB considers is impact. And that's Mr. Hipgrave's first statement, paragraph 62, supplementary, page 94. And there are a range of factors that go into impact, and I will come back to that. And then there is another factor, which I will not describe, but is set out in Mr. Hipgrave's first statement at paragraph 64. Just invite the court to have a quick look at that, given that I'm restricted in what I can say.
Which bundle reference?
Supplementary 94. So I just want you, for your notes, to be able to jot that down, and I will come back to it.
What paragraph is it?
It's paragraph 64. So that's another factor that is considered. Now, he tells us, Mr. Hipgrave, that, and again I'm quoting, all of these matters are put together by the RMB to create a consolidated risk profile for the individual comprising threat, impact of a successful attack and risk. This will also include a recommendation for protective security mitigations, end quote. That's paragraph 65. It's supplementary, page 95. And he then says that the work of the RMB is considered by RAVC. That's paragraph 69, supplementary 95. So that is what RAVC gets when it gets an RMB assessment. It has an assessment that is looking at the things I've just described. The fourth contextual strand is what we know about the RMB assessments that have been done for others and when they've been done. And this is based on the description, which I emphasise is for the purposes of this litigation, of the three broad categories that are described in the evidence. And for the court's reference, that's Mr. Hipgrave's first statement, paras 29 and 31, supplementary, page 86. And giving a broad summary, what we know is that most of those provided with protective security are in the role-based category. That's Hipgrave 1, para 32, supplementary 87. And he says that in general, it's expected that the RMB will consider each principle within RAVC's cohort annually. That's Hipgrave 1, para 66. And that, in general, I should say, appears to be a reference to the annual consideration rather than to the RMB being done in the first place, because at the end of that paragraph, he makes the point that there may be decisions that need to be taken out of the usual RMB process, and he notes that, and I quote, urgent assistance may be required from the RMB Secretariat and such members as are available to assist on an ad hoc basis, end quote. That's Hipgrave 1, para 66. And I already showed you Annex A to make the point that even with those ad hoc, out of the ordinary cycle process meetings, the RMB goes first. He describes the assessment as one important consideration for all decisions on the protective security to be provided to principals. That's Hipgrave 1, para 54, supplementary, page 91. Now, he does say in one passage that the judge relied on that the RMB may be invited by RAVC to consider risk assessing any individual for their potential inclusion within the cohort. That's Hipgrave 1, para 59, supplementary 93. Now, the judge placed emphasis on the use of the word may rather than must. That's in the judgment at para 162. And in our submission, he was wrong to do so because, as the court knows, my submission from earlier today, there's nothing in RAVC's terms of reference that suggests that the RMB is anything other than mandatory for anyone within RAVC's remit. And secondly, there's nothing in the evidence of RAVC's practice to suggest that the RMB was not carried out for those who had previously had protective security. And that is why we say that the appellant has been singled out in this unjustified and, we would say, inferior way. And I'm going to return in the closed session to give you some more submissions about that fourth strand. That is to say, how it's been applied in practice, the individuals to whom it has been applied, and so on. And if I may, I'm going to give placeholders, in case you're taking a note, to say that that's private point 1, so that when I come back to it in closed, hopefully you will be able to slot the submission in to the note that you're making. My lords, the errors in the judgment. There are 3 errors that the judge made. The first is that he said that the 2017 terms of reference did not require RAVC to do an RMB before making decisions as to whether or not someone gets protective security, and if so, what. So he treated it as something optional, and we say that's where he got off on completely the wrong foot. And even though he went on...
Which paragraph is your criticism relating to?
I'm going to go through several, but 162 is the one that I've just described.
Thank you.
Even though he went on to do the good reason analysis, so he considered the possibility that the 2017 terms of reference did require an RMB, we say that his starting point of the discretionary, voluntary nature of it infected that analysis. Now, at the judgment 162, and if I can ask you to have a look at that, it's in the core at 135. the judge makes 3 points in this paragraph. First of all, he says that the terms of reference cannot be treated as hard-edged policy documents. That's about 7 lines down. 162. If that is intended to mean that the terms of reference do not mean what a reasonable and literate person would understand them to mean, then we submit that that's wrong. And that does appear to be what the judge means, because he then goes on to say the words, that the words cannot be taken at face value. And you see that just a couple of lines down. His second point is, he says it's immediately apparent that the words cannot be taken at face value because of the present point, which I've already addressed, so I'm not going to go back over that. I've explained why that is also wrong, that our construction doesn't lead to that conclusion. And then the third point he makes is to say that paragraph 20, like the rest of the document, must therefore be read on the basis that it is being used by RAVC members, in particular at this time the chair, by reference to a number of value judgments. And he says that it is Mr. Hipgrave's evidence that the RMB may not must be invited to do the RMB. Now, I've already addressed that part of Mr. Hipgrave's evidence, so can I just say something about this wider point that the judge is making in this paragraph? This wider point crops up at a number of points in the judgment. So, for example, could I ask you to look at 158, which is on page 134. And you can see there that he says, about 4 lines down from the top, the subject matter at issue and the expertise and constitutional responsibilities of the relevant decision makers will be relevant to the court's task of construing the terms of the policy and the nature and scope of the practice. Now, as I hope is not a surprise to my lords, if that is intended to mean that this is relevant context which informs the court's approach to interpretation, then that's fine. But he seems to want to go further with this point. He seems to say that the court should interpret the policy in the way in which the decision maker has chosen to apply it. And if that is what he means, then that is wrong, and that is the second error in his judgment. So the first is the one I showed you at 162 earlier in terms of interpretation. The second error is this deference approach that he gives to the terms of reference as a whole. And as I say, it crops up in a number of places. Can I just show you another place, which is paragraph 175, and that is on page 141. So again, he goes back to this deference or expertise point. He says that the defendant's witnesses can be taken to have a thorough understanding of the RAVC terms of reference, and you see that 4 lines from the top. Now, that appears to be an application of the Hopkins presumption, because as you can see from paragraph 176, he rejected my submission that one cannot extrapolate from Lord Carnwath's judgment any general proposition. So 175 and 176 appear to be yet more of the expertise point that we've seen in 158 and 162. And you already have my submissions on why Hopkins is not authority for the general presumption that the judge appears to be applying, and therefore these paragraphs show an error of law. Then could we have a look at paragraph 178? This is the third and final interpretation error, which we say is wrong. Here the judge appears to have concluded that the 2017 terms of reference...
Sorry, I lost the paragraph. 159?
178 now, madam.
178,
It's 178. It's on page 142.
Yes.
So this is the third error. And what he appears to have concluded is that the 2017 terms of reference did not apply to RAVC's decision-making in relation to the appellant in 2020. And he doesn't therefore go on to consider the question about the scope of the terms of reference, and in particular who it applies to, and the fact that that is, in our submission, something that is determined by the content of the TOR. So that's the remit point. And we say that his analysis here has 3 mistakes in it. First of all, he ignored the fact that on the evidence before him, he knew that the appellant's interpretation is consistent not just with the language of the terms of reference, but also with RAVC's practice. And I've put it in that way because that's my private point 1 again, which is who else has had the RMB? The judge had heard our submissions on that, and he made an error because he didn't take that into account. He also ignores the evidence of Mr. Hipgrave in Hipgrave 1, para 25. I referred to that earlier as well. That is also a paragraph which I will show you later, and it deals with the remit question.
Page?
Supplementary 85.
Thank you.
And third, he ignores the evidence of Sir Richard, which I've already covered with you, and that's Mottram 1, paragraph 14, where Sir Richard says they weren't applied to the appellant because of his change of status. The judge then, on the interpretation part of the judgment, he looks at the position of others at paragraphs 179 to 190. Now, some of that analysis is about good reason, but some of it bears on interpretation. And so that's all going to be part of my private point 1. So could I now turn to grounds 1B and 1C? The key parts of the judgment that relate to this, again, if it's helpful for you to have them at the outset, are 155, 158, and 159. That's on the law.
Did you say 159?
Yes, my lord. And then on the facts and the application of the standard to the facts, it's 165 to 168, 170 to 173, 175, 180, 186, and 190. I have 4 overarching submissions on good reason, and they fall to be considered against the backdrop of the points on interpretation that I've already made. The first overarching submission is to identify the correct question for the court. And that question applies to both the judge and this court, provided, of course, that this court agrees with us that the judge was wrong. So if, having exercised that decision in our favour, you then wish to consider the submissions, you will also apply, in my submission, the same test as the one that the judge should have applied in the first place. And applying Munjaz and Tower Hamlets, we say the question is this: whether, on the basis of the evidence adduced, the court considers that RAVC has shown that it has a cogent or compelling reason for failing to do an RMB assessment for the appellant. And that is a question of law which this court must decide for itself if you agree that the judge did err in the ways in which I'm going to submit. I'm going to address later on the factual findings on which that decision needs to be based. But can I try and put them into 2 groups? The first group of factual findings relate to the reason for the decision. And these were made by the judge primarily at paras 166 to 168, 170, and 172 to 173. I don't challenge those factual findings as a matter of fact that that is the reason for the decision, save as to the question of weight, which I will address in my fourth overarching submission. And what I mean by that, just to give you a little bit of an explanation, is I will be submitting that the reason that we have in the witness evidence is not the reason we see in the contemporaneous documents. But that's a question of weight. So that's the first group of factual findings, the reason for the decision. The second group are factual findings regarding the RMB, which the judge made, which are at 165 and 190. And the one that he makes at 165 is also repeated at 171. Those two factual findings, we say the judge got wrong, and this court should not adopt them. So that was the first overarching submission. The second is that the quality of the substantive reasoning that is needed in the context of this case and this departure from the 2017 terms of reference is especially high, and there are three reasons for that. The first is the importance of the safety and security of the appellant. That justifies the need for particularly cogent reasoning. I hope the court has had the opportunity to read the appellant's witness statements. He describes in them the position that he has benefited from in terms of protective security over his life. And that is an important backdrop for this point that I'm making now. And so if I could paraphrase paragraph 21 of what Lord Bingham said in Munjaz, we invite the court to scrutinise the reasons given by RAVC with the intensity which the importance and sensitivity of the subject matter, the safety and security of the appellant justifies. Second, we say the clear, unqualified requirement that RAVC's protective security decisions must be based on the RMB justifies the need for particularly cogent and particularly compelling reasons. And I've already explained that this is not based on some literal interpretation of the terms of reference. The court has seen the recommendations of the Tesh Review quoted in the EC and the rationale for why the RMB is so important. And we also have the practical application of the terms of reference. We know from the evidence how widely and consistently the requirement to do an RMB is honoured by RAVC. And there is no other person in all the evidence before the court that has been treated similarly to the appellant in being denied an RMB. And we say that that is the second reason for that especially high threshold. Third, the extent of RAVC's departure from the terms of reference justifies the need for particularly cogent reasoning. And as I said at the outset, as my first introductory point, it's common ground that RAVC has failed to do the RMB in advance of taking the February 2020 decision. And we say that stark and wholesale departure from the requirement of the terms of reference is something that needs to be taken into account. So having made those two overarching submissions, can I just pause to look at the judgment insofar as it relates to what I've just said? I've already addressed substantively the point in the judgment at para 155. This is page 132. This is the Munjaz point. And the judge says there, he quotes parts of Munjaz, and after referring to paragraph 69 and quoting from Lord Hope, he says, I would emphatically reject any suggestion. He says, as will be apparent from what I say at paras 159, the background and subject matter of Munjaz in the present case could hardly be more different. And he essentially then says that what Lord Hope said cannot simply be carried over to the circumstances of the present case. That's at the top of page 133. We submit that as a matter of principle, those comments can be carried over to this case because there's no analytical difference that is relevant between the background and subject matter of Munjaz and this case. Can I just explain what I mean by that? The court will recall that I showed you the 3 points that Mr. Munjaz relied on that were described in paragraph 20 of Lord Bingham's speech. There was consultation on the code in Munjaz, and we say that we have the Tesh review and the College of Policing reports in this case. So just as that consultation heightened the threshold, so the Tesh review and the College of Policing reports heighten the threshold here. This is not advisory. This is not discretionary. This has been developed after taking those reports into account. There was the high importance of protecting detained mental health patients in Munjaz, and as I've just explained, there is the importance of the safety and security of the appellant in this case. So far we have 2 out of 3 in terms of the qualitative points. True it is, of course, that unlike Munjaz, the 2017 terms of reference was not issued by the Home Secretary. But that is not a material factor when it is remembered that there was no express obligation on hospitals to follow the code. So there was certainly a statutory backdrop in Munjaz, but that backdrop does not justify a different analysis on the facts of this case. And then he carries on, staying in the judgment at para 155, he carries on and distinguishes Tower Hamlets on the basis that he says it was also a case about statutory guidance, and for the same reasons we say that's not a material distinction when considering what is required by the good reason test. The court will recall that I said that the analytical search is for factors that show that the policy in question is more than merely advisory. Now, those factors could include things that relate to the statutory provenance of the policy, but they don't have to. And you don't have to have that statutory provenance in order to get into Munjaz and Tower Hamlets. So we say that the judge was wrong at the end of that paragraph to say these cases shed no relevant light on the matters with which I'm concerned. Of course, they don't shed any factually relevant light, but they identify the correct legal test, and that legal test, we say, is to be applied whenever on analysis the policy in question is intended to be very much more than advice which the decision maker might choose to follow or not to follow. That's a paraphrasing of paragraph 20 of Munjaz. So, my lords, we say that the judge erred in the application of the Nadaraja good reason test because he failed to hold RAVC to the Munjaz standard of cogent for compelling reasons. That is the right test, and that is the one he should have applied. He applied a lower standard. Staying in the judgment at paragraph 158, which is on page 134, he rightly noted at the start of that paragraph that the Nadaraja principle is not a rigid one, and he also rightly noted at the end of that paragraph that the expression good reason is a protean one in nature. But that is because the answer to the question, was there a good reason, will always be fact sensitive. That's where we get the versatility. But we don't have a difference in terms of the applicable framework for that question, in principle. That is there a cogent or compelling reason? And then moving through the judgment, at 159, we see that he notes that the decision-making in this case doesn't have a statutory context. He says it's an aspect of the royal prerogative. Again, that's the same as the point I've already addressed, which is the source of the decision-making power doesn't change the need for the cogent or compelling reason. And the court may have noted when I was going through RAVC that that was a prerogative power case. So that was the ministerial statement about the ex gratia compensation scheme. And he says at the end of para 159 that the assertion that Sir Richard should have thought to initiate an RMB assessment is close to being a Tameside challenge, and such challenges are founded on irrationality. That is a bad point in our submission, because our assertion regarding the need for the RMB is rooted in RAVC's own policy, so it's not a Tameside challenge. And then if we see paragraph 176, that is again the expertise point, which I've already addressed. That's page 141. So those are the first and second overarching issues on good reason and why we say that the judge erred in relation to them. My third overarching submission is that the judge's factual findings regarding Sir Richard's reason for not doing an RMB do not disclose a cogent or compelling reason. And I should say, for the avoidance of doubt and dealing with the respondent's notice point, that in our submission, the reason provided would meet the Wednesbury standard. Would not meet the Wednesbury standard. Could I start by looking at the judge's factual findings? I gave you the references earlier, so if I could just go through some of those. So starting at 166, please.
Starting at which paragraph?
Paragraph 166, my lord, page 136. And you'll recall that I said that there were two groups of factual findings. The one that relate to the judge's factual findings as to RAVC's reason for not doing the RMB, and the second to his own findings. So if I can just give you the overview, 166 and 167 are describing the contemporaneous documents. So those are the three emails, 24th, 6th and 7th of February.
Yes.
168 is summarising the witness evidence in Mottram 1, especially para 75. 170 summarises the witness evidence in Mottram 2, paras 36 and 37. 172 summarises the witness evidence in Hipgrave 2. Now, Mr. Hipgrave doesn't address RAVC's reason for not doing the RMB in February 2020, because obviously he wasn't the decision maker or involved with it, but his evidence is purporting to support and justify that decision. So that's why his evidence is referred to there. And there is a similar point which applies to 173, which is the witness evidence of the current chair.
I'm not quite grasping what point you're trying to make by going through these paragraphs which just refer to the evidence.
Because I'm about to make submissions on why he erred in what he found in them, and I want you to know what I'm basing my submission on. So it's these factual findings. It's the description of the emails, it's the bits of Mottram 1, Hipgrave 2, and Mottram 2, I should have said, and the current chair's evidence. And it's those specific passages.
Yes.
In relation to the others, the challenges that he makes himself the findings he makes himself, those are, as I said to you, 165, and the factual finding that he makes there is he says an RMB assessment had at the time certain significant limitations, which is referring to February 2020. And the court will see that on page 136. single sentence is a factual finding.
Right, a single sentence where?
Paragraph 165,
Yeah,
page 136,
yeah.
second sentence.
The
So-
good reason finding.
I'm so sorry, my lord.
It's a good reason finding.
That's a factual, yes, it's a good reason finding. It's a factual finding that he has made that is not in the evidence. It's an inference that he has derived from paragraph 9 of the evaluation criteria paper. So you can see that in paragraph 164 he sets it out, and then he says in 165 it doesn't assist the appellant. He makes that statement, and then he says it supports the defendant's case. And my submission is that there's no basis for that factual finding, and it's wrong. And there are 5 reasons why that factual finding is wrong. And the reason I want to make submissions on it is obviously, as part of the good reason analysis, this court needs to consider whether or not his factual finding is right, that in 2020 the RMB assessment had significant limitations. And we say that, first of all, the basis for this, which is paragraph 9 of the EC, doesn't support the inference that he's derived from it. So can I just remind you of what paragraph 9 of the EC said? It's supplementary tab 12, supplementary tab 12, page 174. So we looked at this earlier, and the bit that the judge relies on is the bit after the redaction beginning the RMB review. So that's the passage that he's quoted in his para 164. And it's essentially a recommendation that there is a more holistic and in-depth look. That's what's being said. The fact that the RMB assessment could be made more holistic and more detailed does not, in our submission, mean that it can be inferred that at that time it was, as the judge found, significantly limited. Nor does the potential for improvement change or diminish the stated role of the RMB, namely, as we see at the start of that paragraph, that it was a crucial part of RAVC's considerations. Third, there's no evidence that supports the judge's conclusion. So Sir Richard's evidence doesn't support that conclusion. And fourth, the contemporary evidence is that an up-to-date RMB would have been of assistance. When considering the arrangements for the June visit, the police asked for the most recent RMB assessment. And you have that in HIP Grade 1, paras 131 to 132. So the police plainly considered that the RMB assessment was relevant for the purposes of the June 2021 visit. Finally, the point in paragraph 9 that's being made is different to the one that is being made by Sir Richard and which the judge describes in para 165. The EC is saying that the assessment could be made more detailed. Sir Richard's evidence is not that the RMB wasn't detailed enough. That's not what he has said. He has said that the RMB wouldn't have the information they needed in the appellant's case to meaningfully do one part of the assessment. That's his evidence. And I'm going to develop that point in the closed session, but the headline point is that the judge appears to have misunderstood Sir Richard's evidence on this. That factual finding in 165 is repeated, as I said, in 171. It's put in a slightly different way. But then, if I could ask you, let me just show you that, please. It's 138. And he says, far from assisting the claimant for the reasons I have given, and then over the page, the evaluation criteria support the fact that at the time an RMB assessment of the claimant would have been likely to be of less practical utility than the visit than certain arrangements. So that is a very similar point to the one he's making in 165. And then, if I can just show you quickly some bits of 172, which I'm going to come back to. He refers to the fact in 172, he refers to Mr. Hipgrave's evidence, and I think it's just over halfway through that paragraph. This means that a more focused, much more focused. Do you have that, my lord?
Yes.
That bit there, much more focused consideration can be given, informed in particular by the views of the MPS. So that, and then you see the latter part of that paragraph, which I'm not going to read out, in terms of what Mr. Hipgrave says about the role of the RMB. And similarly, in para 173, you see the evidence of the current chair. And if you go over the page, you will see that there is a passage which is redacted, which explains his view. The quotation begins, allows RAVC to reach.
Yes.
So the judge took into account all that evidence, and I'm going to address this in the closed session in detail by reference to what the RMB does, what is done in the bespoke process, what the difference is. I'm going to try and answer my Lord Master of the Rolls' question to me about how this figures, basically, in relation to the appellant. But I wanted to show you now that those are the passages I will be challenging. And then in 190, the judge says, and this is page 146, he refers to Sir Richard's view that it was not possible for RAVC at that point to see how matters regarding the claimant would develop. I'm reading from about halfway down in that paragraph, and then there's the sentence, the position would not have been materially affected if an RMB assessment had been commissioned at the time. That's another factual finding that I say is wrong, and I'm going to deal with that also when I deal with the closed evidence. I should just say it's not entirely clear what the judge bases that assertion on. It appears to be based on the passages I've shown you. So the bits from Mottram 1, Mottram 2, Hipgrave 2, and the current chair's evidence. But in any event, I'm going to come back and address on the evidence why those factual findings don't, in our submission, warrant being upheld. The rationale found by the judge to explain the lack of the RMB does not, in our submission, disclose a good reason for 5 principal reasons. Now, I can't articulate all 5 of them now. I'm going to address them in private point 2, but can I just give you the essence of what the submission is going to be? The RMB is a fundamentally different exercise from the so-called bespoke process. It's done by people with specific expertise and it focuses on distinct factors. The fact that the appellant is living abroad and comes back here from time to time does not in any sense dilute the relevance of those distinct factors when his security is being considered. And the so-called bespoke process and the expertise being applied to that process are, in our submission, not only fundamentally different, but fundamentally inferior for the appellant than for any other individual within the RAVC cohort. And I will develop all of that in the closed session and submit that in light of that analysis, there's no good reason, let alone one that is cogent or compelling. The fourth overarching submission I have on good reason is that little weight can be attached to the witness evidence, because first of all, the explanation in the witness evidence is not to be found in the contemporaneous documents, and second, the witness evidence has been given almost 3 years after the decision in question.
Same point, is it?
My lord, no, in the sense that, well, perhaps I can show you the documents, because the documents are so thin that it's very difficult to understand what they mean, let alone distill
The contemporary documents.
The contemporary documents. So that's one point. We don't see it. And when one has to recollect that the terms of reference, especially back in 2017 when the chair was making these decisions, one would expect the chair to be comforted by the framework in the terms of reference. They're there to protect him as much as anybody else. That wasn't followed. That process wasn't followed. As I've said, it's common ground. And so you might expect that the chair in that position would be taking great care to document what he was doing in this. In his own evidence, he describes it as an unusual and high-profile case. But we don't see that. So that is the contemporaneous documents. But the second point is the passage of time when it is about something that was in someone's mind, an opinion or a belief. And my lords will be familiar with the difficulties of any witness recalling what was in their mind 3 years after the event in question, especially when the underlying documents are so thin. So this really does just go to weight, though, as I've said. The judge gave the witness evidence significant weight. That was how he described it. In my submission, it has little weight because of those two factors. Can I show you the first of the emails in question? This is tab 20 of supplementary bundle, and it starts, as with email change, you have to work backwards. It starts on page 207.
In the supplementary, right?
Yes, and I'm so sorry. Could I just ask you to look at 206 because you can see the sender. So you can see it's from Sir Richard at the bottom of 206. It's 24th of February 2020, sent at 1910. And you see there the names of the recipients.
Yes.
And can I ask you just to have a look at this email? The two sentences after the bullet points.
Oh, I must be in the wrong one. Yes.
So you see the bullet points, my lord.
I've got it, yeah.
And I think it's two sentences, but
So
in any
this
event,
is
it's
the
a line and a
24th
half.
of February email.
24th of February.
Yes, thank you.
If I could just ask you to read that little bit that is outlined in the green.
Yes.
And it's the 7th, 8th and 9th lines. That are the focus there. So my lords see that.
As we discussed.
Yes. And then the section which is unredacted, if we follow this line of argument. So the argument is there above, and then the consequence of the line of argument, as he puts it, is there would be no RMB. So that is the sum total of the contemporaneous explanation from the chair. Now, what we have in response to this email is one of the recipients querying what it means. So it's so unclear that one of the recipients doesn't even understand what its meaning is. Can I show you that email? That's on page 204. And you see halfway up that page who it's from. That person was one of the recipients. It's sent 2 days later on the 26th of February. And you can see there that he says...
Yes, you're referring to point 4, are you?
No, my lord, I'm referring to point 1. He says, following your email on Monday,
Got it.
am I correct in understanding this means that there will not be, and then you can see what's set out there. So the person getting it didn't really understand. And you can see the last sentence, I suspect we will be pushed for this clarity. So, big red flag for Sir Richard. Haven't explained it particularly clearly, and we do need it to be clear.
I mean, big red flag might be overstating that paragraph, mightn't it? He's understood it, actually, because he repeats it.
Well, but it's somebody else, my lord. It's never a good thing if somebody has to say back to you to check whether or not they've understood what you've meant.
Okay.
And also, there is that point about being pushed for clarity. So there was an opportunity for Sir Richard to come back and explain, and we see his response on page 203. And you can see it's 2/3 of the way down. You see that's the response from him. It's the 27th of February. It's going back to that same person. And his response is, your understanding is correct.
Yes, but so what's wrong with that?
Well, if you now go back and look at what was said in the clarification, so if you go back to para 1 on page 204, it doesn't say anything in terms of the methodology not being meaningful, which is the explanation we have in the witness evidence. What it's saying, if I can paraphrase, is we're not doing the RMB because we're doing something else. So what you see in the witness evidence now, in my submission, is nowhere to be found. It's not in Sir Richard's first email. It's not in the clarification.
Sorry, just be a bit clearer, can you, about that submission? I don't fully understand it. Just say it again. What do you say is in the submission now that is not prefaced in the documents we're looking at?
An explanation.
An explanation for what?
Not doing the RMB.
Right, so you say there's no explanation for not doing the RMB in this email exchange.
Well, it depends on what my lords, regard as an explanation. In my submission, it's not an explanation. What it says is, we're not doing X because we're doing Y. It doesn't say, we're not doing X, we're doing Y because. And so in my submission, to say that you're doing something other than you should be isn't explaining why you're doing it. What you get now in the witness evidence is the why. You get the, we're not doing the RMB, we are doing bespoke because. There's no because in these 3 emails.
I mean, can you say why they say in the witness statements? I can't remember if it's confidential.
In a nutshell, it's that the RMB's methodology no longer suited the appellant's circumstances.
Right.
I think that's as much as I can say. But I will come back to it, my lord. I'm not going to leave you with that rather short explanation.
I see it a bit more simply than all this. It's this afternoon you made, if I may say so, some rather closely reasoned submissions by reference to bits of evidence here and there and the judge's reasoning. But these emails seem to me to sort of say what they mean and mean what they say. They say in very simple terms, and things don't have to be complicated just because they're important, right? I mean, I hope you would accept that at least. You don't have to have 500 pages to say a very simple thing, like, for example, the safety and security of the claimant is very important. That only takes a few words. And these emails, just reading them fairly, do seem to say, and I'm reading out something that I think is not redacted, there will not be an RMB on the grounds that this is no longer required given alternative governance arrangements being established for the claimant. So there's another solution. That's what's being said. Now, you say that's wrong based upon an interpretation of the TOR, terms of reference, that there has to be an RMB. Now, what if there doesn't have to be an RMB? Why is that reasoning so flawed?
Well, this is why we need to go back to everything I've said. I'm not going to repeat myself, but my lords have my point about clarity, logic, and convincing. When you're looking at the material, I'm asking you to look to see whether there is a clear, logical, and convincing explanation. I agree with my lord that it does not need to be 500 pages long. The brevity of the emails is not the point. It could have been succinctly stated. But the brevity is an indication of the thought that was perhaps being given to it. But what you don't see...
I mean, you're not suggesting this wasn't taken unbelievably seriously, I'm sure.
I'm not suggesting that at all. I'm suggesting that the reasoning that we see is not clear, it's not logical, it's not convincing. And the reasoning we see in the witness statement is similarly, as I will develop in the close.
This is why I'm picking you up, Ms. Fatima. You state that as if it is obviously the case. But
which bits, my lord?
You state that the reason given that I read to you a moment ago is not cogent, convincing, and whatever the other word is you use, as if it's a fact. But what I'm trying to get you to explain is why you say, when they are considering the situation, I put it to you this morning as well, of a member of the royal family who's stepping back from his public duties and going to live abroad, and will come back on ad hoc occasions yet to be specified, and I'm conscious that some were specified in an email from the private secretary, but leaving those aside, why it is self-evident, or why we should take it as self-evident, and hold that it was the judge was self-evident but wrong about this, that an RMB wouldn't have helped in the decision that a bespoke arrangement is a better arrangement for this person,
Well,
and the protection of
yes.
this person.
Yes, and my lord, I am in some difficulty, as I hope the court will appreciate, because I cannot give you my full submissions.
Well, no,
So,
but I mean, is your full submission, but I think we do get the point. We understand what private point 1 is and private point 2. I mean, is your submission the comparison with others, or is the submission, what is it that makes it self-evident that this was not cogent?
I entirely see where the court is coming from. You will recall that when I gave you my contextual points, the second, the third and fourth was the information that RAVC gets when it does the RMB, and how it's then approached that for others. So there are two parts to the answer to my lord's question.
Right.
When I will hopefully show you what the RMB does in more detail, when I can make more candid submissions showing you, it will be my submission that there are things that the RMB does, very significant things, views that it gives that are now being done by others. Now, one has to anticipate and assume that Sir Richard knew that when he was writing these emails. He knew that in depriving the appellant of the RMB, he was going to be taking a decision which meant that this person was not going to be getting all of that analysis.
Well, there had been an RMB earlier, right?
Yes?
Yeah.
But one wasn't going to be done before the 2020 decision. So that's one part of why I say not cogent, because the chair knew, I infer, I hope reasonably,
What an RMB was.
what an RMB was and what the benefit of the RMB is as compared to the something else. Now that requires me to evaluate...
I mean, this is why I'm bemused, really, because something else might easily be an RMB.
But we know it's not.
Different time.
Of course, but we know it's not. We know it's the bespoke process. So instead of the RMB, I'm going to give you a bespoke process.
But we don't know that. At this point, we don't know that. What he's saying in these emails is governance arrangements will be established. I mean, I don't think it's confidential on a case-by-case basis. You know, that's what bespoke means. So we're setting out
Could I just ask my lord to look at page 204 just to make sure?
I am on 204.
Just the little bit in green. Yes, I just wanted to...
I'm looking at point 1 of the email.
Yeah.
And that's what he says is correct.
Yes.
Yes.
So, in fact, my lord has made one of my points for me, which is it wasn't even articulated what the process was going to be at that stage. So it's even worse, because it's not RMB, but here I have another crafted solution. It's RMB, but I'm going to do it as and when.
You see, this is the trouble with subjecting this kind of decision-making to this kind of very, very close scrutiny. And I'm not saying if you're right about the fact that it has to be subjected to this very, very close scrutiny, then you're right, and we will have to do it not only in this but in every other case. But the problem with it is that the decision he takes here is not as to what everything that's going to be done in the future.
No.
The decision is that there isn't any point in having an RMB now because he's changed his position and
Yes.
leaving the country, and we don't know how much we'll see of him in the future. But when we do, we'll have to take case-by-case steps.
Yes.
Now, to say that that decision has no good reason, is irrational, or anything, whatever language you want to use, is difficult because it's sort of kicking the ball down the line a bit. And
Well,
saying,
I'm not doing that, my lord. I'm saying...
No, you're not kicking the ball down the
But
line.
he's-
But maybe
This
Yes.
decision is only about as an interim stage.
But, well, could I analyse it in this way? That there's the what we're not going to do, and there's the what we're going to do. The what we're going to do is unclear, as at this particular time frame. Obviously, we now know what has been done, but as at 24th, 26th, 27th February...
But you're putting, if I may say so, and I don't want to put it too colloquially, but you're putting your money on the absence of an RMB as at February 2020. And what I'm suggesting to you is that this decision is not really making any final decision about when there will be an RMB. It's just saying that the claimant is leaving the country, stepping back from royal duties, and will deal with what happens in the future in the future.
Yes, and there's a response I want to give, which I'm not able to give to that particular question, because it's confidential information.
Well, you've given me two answers, I think, actually. Since I know what's in the confidential information, I don't actually...
Well, it's about the things that haven't been done.
Yes. It's about the nature of the RMB, which, as you told us, and it's about others. Is that right? That's right.
There's another part to it. I'm not trying to be...
That you can't even...
That I can't say. I can't say.
Right.
But my Lord, I'm not putting all my money on it not being done at this particular point in time, because we are where we are in the point in time, and my Lords have evidence, and I will take you to it about what has been done in the interim. Now, can I just...
to appeal, but I thought one was that the judge erred in concluding that there was a good reason not to follow the policy of the executive committee, and that the policy was that an RMB should be done before taking a decision. I thought that's what it meant.
I'm so sorry, my Lord. Could you just repeat
Your
that?
ground says the judge erred in concluding that there was good reason not to follow the policy, the terms of reference.
Yes.
And I understood you to be saying that what they didn't follow was to commission an RMB.
Yes, that's correct.
Yeah. So that's why I said you had put your money on the decision not to have an RMB in the letter of the 28th of February.
Yes, but what's relevant to considering that is what has been done. So I think my Lord gave me the example. They could have done RMB plus plus plus.
Yes.
It's highly unlikely that we would be here if that's what they'd done. The reason we're here, given their failure to do the RMB, is because of what has been done. So it's a comparison between what he is entitled to in our submission and what he's got. That's why the failure matters. That's why they needed to have a good reason. It wouldn't have mattered if what he had gotten was equal to or better than what he was supposed to get. So that's what I mean about it's not just all on the negative, because you can only understand how much of a negative it is when you evaluate it or compare it to what has happened.
I mean, you'll forgive me if I'm wrong about this, but I'm not sure how much it's permissible to place any great reliance on the fact that I'm only questioning a decision made in February 2020 because of what happened in 2023. In a sense, you do have to be able to establish that the decision made in 2020 was wrong under the policy in 2020. Do you
Yes,
not?
absolutely. Absolutely.
I mean, you may say, well, I wouldn't be here in court if other things had happened, and that's a perfectly reasonable thing to say, but it doesn't affect our decision-making as to whether the judge was right or wrong.
Yes.
Right?
Yes.
Anyway, I've tried not to interrupt you. And
Oh, no,
I haven't very much, but you haven't got much time left. Which
No,
is what
I've actually made more progress than I had hoped, so I think I'm all right for time. But my Lord, can I just say this? I will address the concerns that my Lord has expressed.
No, and you'll have overnight to think about it.
Yes, but I'm also restricted, as I hope the court will appreciate, in laying out all my wares today.
Yes. Well, for my part, I've got one or two questions I'd like to ask, but I propose to do that tomorrow.
Thank you, my Lord. Can I just find my spot again, please? So I had shown you the evidence, and I just want to show you the judgment on the evidence. 169.
I mean,
It's paragraph 169, and it's page 138.
yes.
And he says that the 24th of February email suggests that there would not be a need for an RMB because there would be a tripartite mechanism, and you can see the rest of that sentence. Now, the judge says, later you can see in para 170, that contemporaneous evidence is compatible with what's said in the witness statement. And the court has the point that I've made, which is the lack of the explanation in the contemporaneous evidence. And then 174, he again makes a similar point to which we have a similar response, which is the chain says that there would be a change but doesn't explain why. And then the significant weight that I referred to earlier, he says in para 174, and you have my submission on that weight and why we say it can't be given that weight. Now, Sir Richard's first witness statement refers, and this is again the distinction between the contemporaneous and the witness statement point, his first witness statement refers solely to the fact that he had in his mind that there may be significant public upset, is the way he puts it, if harm came to the appellant. That's Mottram 1, para 99. His second witness statement says that he had regard to the impact of a successful attack on the appellant. So that's Mottram 2, para 11, supplementary 147. And the judge relied on that evidence in concluding that there was a good reason. So this was part of the evidence he took into account. He had the emails and the evidence about the change, which I've shown you, but then he also took into account this evidence about impact. And this is particularly important because, as I said to you, the RMB considers impact. And the judge relied on this, you can see, at para 186. You can see there he describes this. The problems with this paragraph and with this reliance on Sir Richard's evidence is Sir Richard does not articulate how impact was considered. And there's no suggestion that it was in the structured way that we'll come on to see is done by the RMB. And there's nothing in the contemporary materials at all about impact. Now, all of that is to say that on one of the major strands that the RMB considers, that is impact, we have the witness evidence of significant public upset and impact of successful attack. We don't have any more. The court doesn't have any more as to how that was done, what was done, and there's obviously no paper trail. Now, again, in terms of my lord, I see my lord the master of the rolls.
Well,
I can anticipate what's coming, my lord.
500-page point, isn't it?
No, my lord, it's not. It's really not the 500-page point. It's that actually there is not an explanation for a critically important part of what the RMB does.
Well, the judge says it would be bizarre if they didn't have it in mind.
Of course, it would be bizarre if you didn't have it in mind in a general sense. I'm sure if you stopped anyone on the street and said, you know, if an important public figure was hurt, what would you think the impact would be? Everybody would have a knee-jerk reaction. That's not what the RMB does.
No.
But RAVC itself, I mean, the judge says the impact both at home and abroad of a successful attack on a particular individual lies at the heart of the rationale for RAVC's existence.
Yes.
So what else are these people appointed for?
Well, my lord, when you say these people, I would say the RMB and RAVC. That's the point. It's a dual-layered system by design. And so I entirely agree with you if you're reading RAVC as including there the RMB. And that's the whole point. That's why we're here, because we're saying, yes, of course this is what RAVC does when it does it properly. When it gets the RMB to look at all of these things that it has said the RMB should look at after recommendations in a review.
And I think I, anyway, understand. This is a process challenge. The RMB is separate from RAVC. RMB has special expertise and would have addressed the impact on the claimant in a way that it has done for others. And in those circumstances, you say it is unfair and inappropriate and improper not to follow the terms of reference. And that's very clear. And you say it's not any use saying, well, there's other things you could do without a very close analysis of why that is sufficient in comparison to the expert analysis of the RMB.
Especially when one looks at how others have been treated.
Yes, well,
that is
included others, because
yes.
I know that's a large part of it, but we're not going to discuss others in open.
No, but my lords, that explains that this isn't some arid point about, oh, well, your process says you've got to go to that body and you didn't, and that was bad. This is about substance, as I've shown you by going to the evaluation criteria, but it's also about, let's actually look at how the RMB came out on these cases and what's happened here, and I will be asking the court to look at the individuals. I will be asking the court to do that. That's my ground too.
Yes.
And I will be saying it is irrational.
Yes.
It is irrational. Well, it's a different point, but it's part of this analysis of impact. It is at the heart. It's
1C or 1D, yeah.
Yes, 1D and ground 2. That when you actually look at how the RMB has evaluated impact and the conclusions that RAVC has come to, taking the RMB report into account, and then you look at what RAVC has done for the appellant and the conclusion that it has come to, something has gone wrong. It does not make sense. That is what I am going to be submitting. And so I don't want to be labouring the point about the RMP and the terms of reference, but one doesn't understand the significance of this until one gets under the bonnet and looks at how things work.
Your answer to my lord is the RMB is qualitatively different.
Precisely.
From RAVC.
Precisely.
Different expertise.
Yes.
And a different outcome.
Yes.
And he's been deprived of that, and
yes.
he should not have been in the circumstances of February 2020.
Yes. And to respond to my lord, I'm not trying to in any way say that RAVC doesn't have expertise. I said that at the outset, but my lords have seen that the RAVC expertise kicks in at the risk evaluation stage, not the risk analysis stage, and that's RAVC's own choice to have done it that way. Two-tier. So RAVC is, of course, considering, and the judge rightly notes, of course,
risk evaluation and risk analysis.
Yes. So
RAVC is risk analysis, RMB is risk evaluation.
The other way around.
Sorry.
So, my lord, that is ground 1B and C, and I'm going to just do grounds 1D. I think the way that we would put it, if I had to put it in a nutshell, is that we would say there's nothing better than an RMB.
Yeah.
And that's why it's used for everyone else. Now, just grounds 1D and 2 in brief, because I can take this quickly. I'm going to deal with ground 2 in the closed session, because so much of it is the comparison with others. But just for my Lord's note, that's the judgment at 181 to 192. So just a few words, if I may, on ground 1D. Ground 1D does not appear to have been expressly addressed in the judgment at all. And the court may have seen that in paragraph 250, the judge notes that we made some points after we had received the draft judgment. And this is, if I can ask you to pick it up from 165, you'll see that he says that after circulation of the draft judgment, the claimant invited the court to refer expressly to the following submissions that the claimants had made in the course of the hearing. And then over the page, it's the third point in that paragraph. Third, the claimant says that without an RMB analysis, RAVC could not lawfully reach the conclusion that the claimant should not be treated as within the OVC. And what the judge says in paragraph 251 is essentially to say that there are further examples of the overarching problem with the claimant's case, and then to refer to other parts of his judgment. Those other parts don't appear to address this at all. So you see he refers to paragraph 201. That's not something that deals with this, certainly not expressly. What ground 1D is trying to get at is that when Sir Richard made the decision in February 2020, he didn't have a proper factual basis on which to consider whether or not to treat the appellant akin to the OVC, because he wasn't properly informed. And that's because we say he didn't have the RMB. So he took a decision about how to treat the appellant without thinking about it in the way that the terms of reference require. So you can see that this point builds on the other points, but it's really, again, the point about impact. And if I ask you to have a look at Mr. Hipgrave's witness statement, the first one, paragraph 62, just for your note, I'll go to it tomorrow. We say that in light of the matters set out there, the failure to get the RMB in February 2020 means that Sir Richard wasn't properly informed, especially about impact, and therefore he couldn't make that proper decision about the protective security. So I appreciate these are broad categories, and I'm not trying to suggest at all that, you know, they're formal categories and that RAVC treats them as distinct. But in terms of what you've seen in the emails about how he was approaching this, once that question 2 had arisen, which you saw in his 24th of Feb email about the fact that he wasn't in that role anymore, but we still have this problem, at that stage the answer was, let's get an RMB and then figure out how to potentially categorize him. And I don't mean by that in a bucket of, you know...
No, but you say they needed an RMB before they could categorise him as an AVC or not, and they didn't do that, and they weren't in a position to do it.
Exactly. So it's a very short point, but it's an important gateway point.
The evidence on it will require closed session.
Yes, and that's the ground 2. So it's really the gateway point to ground 2. So, my lords, I'm going to come back and deal in private with the points I've flagged.
Yes.
But those are the submissions.
Thank you very much. Sir James.
I was just briefly, by way of introduction, if I may, the decision under challenge is the one in February 2020, as the Court has noted on a few occasions now. That's in the core bundle at page 367. And it was, in a summary, that the appellant would no longer necessarily be provided with the same degree of publicly funded personal protective security when in Great Britain, following on from his change of status. It's important to emphasise that the decision was not that personal security of the kind previously provided would under no circumstances be provided in the future. Rather, it was simply that that security would not be provided on the same basis as before because of his change of status and because he was now going to live abroad for the majority of his time. But he would be provided with personal security to the extent appropriate in certain circumstances, and those circumstances would need to be considered in the future. That was the nature of the decision. So the decision in overall, but we submit accurate summary, was that he is now in a bespoke position with bespoke arrangements having been made for the consideration in whatever detail RAVC and the other bodies involved consider appropriate in the future. And once that is apparent, it is self-evident, we submit, that we are in territory in which there are no right or wrong answers. There are matters of judgment against necessarily broad and soft-edge criteria, especially predictive assessments of risk and impact and all the rest of it, including matters on which the security expertise of those involved is likely to be critical. The key evidence in relation to the decision-making and the reasoning of RAVC is set out in a long and very carefully detailed section of the judgment between paragraphs 83 and 135, going through, as you've seen, with great care all of the evidence. Particular reliance was placed by the judge, we submit entirely properly, on the two statements made by Sir Richard. You find those, if you want them, in the supplemental bundle. The first one, tab 2, page 34, and the same bundle, tab 7, page 144, is the second one. He was the chair of RAVC from 2009 right the way up till April 2021 and is now retired. And also in the statements of Mr. Hipgrove, again you've got two witness statements from him, or the court below had two witness statements from him. Supplemental bundle, tab 4, page 79 is the first one. Tab 9, page 159 is the second one. And you have their background and their experience, and indeed their expertise, summarised by the judge, particularly at paragraphs 11 and 16 of the judgment. I emphasise one final point by way of introduction. Most of the careful and detailed description and analysis of the judge, the detailed description of the evidence, of the decision-making, of the factors taken into account in considering his personal position, and so on, and indeed the myriad other grounds of challenge, are no longer challenged in this appeal. And therefore the rest of the judgment, as it were, aside from the grounds, the relatively narrow grounds on which permission has been granted, now provide the unchallenged backdrop against which those narrow remaining live issues fall to be considered by this court. It is therefore, for example, uncontroversial in this appeal that the decision did not fail to take into account any material consideration. That was old ground 2. It was dealt with described by the judge in terms of the description of the ground at 137 of the judgment, and was disposed of at 238 to 249 of the judgment.
Well, all you're really saying is they didn't get permission to appeal on the other matters.
My lord, they didn't, and there's been no application to revisit
No,
that.
absolutely, but, you know.
Can I just give you
doesn't mean it's common ground.
I'm not suggesting it is.
No.
But it is important for the court to appreciate what is no longer live at this level.
Yes, well, I think we understand it's definitely not live at this level.
Very well. In which case, you will also note that what is not live is that the security arrangements in the decision were not unreasonable. That was the rejection of the rationality ground, 138 of the judgment, and then 238 to 249, where the judge took grounds 2 and 3 together. And there was nothing procedurally unfair about the decision-making. That was ground 4 and ground 5 below, described at 139 to 140, dealt with 213 to 232. So what is left are a collection of subgrounds under misapplication of the policy, no good reason to depart from the policy. And we submit that that ground 1 effectively breaks down into 3 points. First, that the judge, it is said, failed properly to construe and apply the terms of the 2017 TOR and should have held that in every case, in every context, an RMB analysis must be obtained before a decision is taken by RAVC on the provision or not of protective security and needed to be taken here. In brief summary, and I will develop each of these in a moment, but in brief summary, our response to that ground is that it requires an overly rigid reading of the terms of reference. And in any event, it is clear that there can be departure even from the most rigid and anxious, if I can describe it in that way, policy. The second point that is made is that in considering whether RAVC had good reason to depart from the ordinary approach of an RMB assessment, the judge was wrong to show respect to the primary decision maker, to recognise that there was no relevant statutory context here bearing on that question, and to treat that as significant, and to draw on an analogy with the Thames-side duty, which, as you're all very well aware, is a duty to make rational inquiry. And our submission in brief response again in relation to that second main way of putting the case is that the judge was right to recognise the relevance of the expertise and indeed the constitutional responsibilities of the relevant decision makers in concluding that there was good reason in this case. And we've got a respondent's notice point, as you know, which it might be thought to be dancing on the head of a pin to some extent, but we raise it anyway, which is a question of law as to how you approach that question.
That point is actually of some importance.
Some broader importance.
It may not be in this case, but it's of great importance.
It is. It's whether or not it's a rationality standard or it's an objective thing for the court, effectively. We're back into that territory, but you'll have seen the significance of that, but that fits under the second point.
Yes.
And of course, if a rationality standard is to be applied, then ground 1 rather falls away in the light of the findings as to the rationality of RAVC's approach that were made by the judge and that are the subject of a live appeal now. That's the second issue, anyway, or the second 2 bits of the second issue. The third main point is that the appellant contends that the defendant, RAVC, did not have a good reason to depart from the usual policy of obtaining an RMB assessment.
No good reason, cogently, and other adjectives expression.
Well, there'll be a question about that, but to some extent that takes one back into the expertise issue, because you can produce any number of adjectives or adverbs to describe a concept, but ultimately what may matter is the substantive things that feed into the level and degree of the court's scrutiny. And my lord and I have had that debate on a few occasions in the past, including in relation to controversial policies like Rwanda.
I have a vague recollection of it.
I thought, you're not the only one, I thought. So anyway, that's the third basic thing. And again, in summary response, we submit that the usual position, which we fully accept, as set out in RAVC's terms of reference, was that decisions on the make-up of RAVC's cohort would be informed by an analysis produced by the RMB, but here the decision made by the experts involved, including, I add at this stage, both the chair of RAVC and the chair of the RMB, who was the main second party to the email correspondence you've just seen, was that a different approach was not merely appropriate, but a better one in the circumstances. We will say, secondly, that there was good reason, however judged, by which I mean by reference to whatever standard that is judged, and it lay in the appellant's unique circumstances requiring the sort of bespoke approach that one has seen, for which purpose, i.e. for the purpose of those unique circumstances, the RMB assessment was neither appropriate nor especially informative. And as an aspect of that, and finally, the conclusion was that bespoke process was better suited to the appellant's circumstances. So the decision was, in essence, that the appellant would be better served by this approach, not, as the appellant appears to assume without foundation, deprived of some form of useful procedural benefit or advantage. And indeed, it might be thought to be a striking feature of this case that the appellant is complaining that it was unlawful for the decision maker to consider his case directly and specifically, and to go on, by virtue of this decision, or deciding to go on considering his case directly and specifically in the future, rather than simply applying a more broad approach to it. That is, might be thought rather the reverse of the usual case, which is to argue that there should have been less discretion exercised and not more. I leave ground to that the contention that it was impossible for the defendant to conclude that the appellant should not be treated as falling within the other VIP category for close, for obvious reasons.
You haven't mentioned in your 3 points the point that Ms. Fatima made quite a lot of, even though she's going to give us the detail in closed, which is the comparison with others, and that there isn't a good reason when you compare with others.
Well, yes, I'm going to pick up, to the extent that I'm able to in open, I'm going to pick that up probably tomorrow now.
Yes.
There will be something that can be said in open, but it's very limited for all the reasons that you're well aware of.
But, I mean, obviously that does form a major plank
Of the appeal.
of the appeal.
It certainly does, but there's a particular limit and a greater limit on what can be said in relation to that ground by either of us.
Well, no, that's true, but I think it comes into the paucity of reasoning that was pointed out in the emails, which you are going to have to address.
Yes,
which
well,
you can
well,
address in open.
I'm going to address those emails in open. I'm going to address, to the extent I can, do ground two. Can I turn to the first argument, and the first of the main points that is raised, which is the interpretation of the 2017 RAVC terms of reference. We've dealt with that in our skeleton at paragraphs 12 and paragraphs 20 through 26. Two principles of relevance, if I can start with the principles, if I may. The first is that the interpretation of a document, a policy document, a guidance document, whatever it may be, whatever its essential character, is an objective question for the court, as we accept, although the policy, if that's what we're dealing with, is not to be interpreted as if it were a statute or a contract. And we get that proposition, which reflects, I think, a degree of common ground between us, from Mandalia that you've seen at paragraph 31, Authorities Bundle, page 485 to 486, tab 12 if you're in hard copy. I don't know, is any member of the court on hard copy? Otherwise I'll just drop the tab references. I don't know if my Lord Justice Bean is.
I am for authorities, but...
Would it help to have the tab numbers?
In fact, the pagination is wrong because
okay,
the versions have been changed.
I'll
But if you just give pages
and
paragraphs within the judgment...
Yeah, paragraph 31 of Mandalia, 485 to 486. Suffolk Coastal at paragraph 22, per Lord Carnworth.
You call it Suffolk Coastal.
I'm calling it Suffolk Coastal. Is that a wrong reference?
Isn't it?
Hopkins Holmes.
Yes, Hopkins.
Yes, Hopkins Holmes. Sorry,
it's the same.
I don't want to cause confusion.
And you are.
It's the same. Well, I'm sorry. Hopkins Holmes. I'm going to come back to it. It's tab 16 anyway, page 633 to 634.
Yeah.
The second principle is that precisely because a policy is not a statute, but is a document which has been adopted in a specific context and is usually being applied by decision makers familiar with it and the public interests it serves to further, particularly when one is dealing in a context where there is expertise, the Supreme Court has emphasised that the courts should respect the expertise of specialist decision makers, and as it was put in Hopkins Holmes, so we don't have the confusion, paragraph 25, start at least, as Lord Carnworth put it, from the presumption that they will have understood the policy framework correctly.
That is directly challenged in
is.
this appeal as being applicable here.
It is.
Yes.
And I'll address that immediately, if I may. The basic challenge that my learned friend mounted this morning was to say you can't extrapolate any form of general principle from that because it was a planning case. It was all about planning, as she put it. And my riposte to that, first riposte to that, is that it wasn't all about planning in the sense that she refers to that phrase. It was all about expertise. You'll recall the passage in Lord Carnworth's judgment, and you probably ought to read paras 22 through to the end of 24 as a piece, because he cites from earlier judgments of Lord Reed about the RAVC principle, it being an objective matter for the court in ordinary cases, and then goes into the expertise bit in paragraph 24, which is the critical one, 24 and 25, which is the critical one for our purposes. But my first response to my learned friend is that statement of principle, start at least from the presumption they will have understood the policy framework correctly, is particularly linked and attached by Lord Carnworth as a principle to expertise. So it isn't some sort of strange planning principle.
No, but what Ms. Fatima submitted was that this is different because it's not some kind of guidance, policy by way of guidance. It's a policy by way of a clear process from which you are not intended to depart because it's telling you what to do. And you don't therefore depart from it just because you say, I'm an expert, I'm going to depart from it.
Well, no one says you do that. Just you can't turn up and say, I'm an expert, so you don't need to bother with any of this.
No, that's what she is submitting, is the reason why deference is inappropriate here. It's not just because it's planning, although that's the context of that case, but it's because this is a policy which tells you what to do.
Just as the planning policy documents told the planning people what to do.
Well, the planning as we know, we've all done planning cases, Sir James, and they are slightly different, but you say anyway that it is a principle that is applicable across the piece.
I said
and you are departing from guidance in a policy, even if it is
telling you what to do.
Unequivocal. Yes.
Yeah, I do say that, but I don't need to go that far. And if by across the piece you mean in every situation in which policy is promulgated by anyone, I don't need to go that far, because the principle that, as expressed by Lord Carnwath for the Supreme Court, was tethered not to planning and the weirdnesses of planning, which we all know about, but to expertise. So there's a particular reason.
Well, I mean, can I just put this to you? The other cases in the immigration context, it isn't right to say that expertise is unique to a situation like this in security matters or planning matters.
No.
Even in immigration matters, where you have some very clear policies for decision makers to follow, the decision makers do nothing else but make these decisions on the basis of these policies. And what I think Ms. Vatimus submits is it's a distinction without a difference in this situation.
But that would apply equally to undercut the application of it to planning, because you could say that about planning. My submission is that in relation to immigration, to take that example head on, it will depend on what the policy is and who's doing what with it.
What she says is that there it is quite clear that despite the expertise of the people making the decision, you don't pay deference to their expertise. You look to see whether they have followed the effectively mandatory guidance, and then if not, you look for a properly, cogently explained good reason. And that, of course, you bear in mind that the decision has been taken by an expert, but that's not the beginning and the end of the matter.
Well, none of the reasoning in those immigration cases puts it the way my Lord has put it. You take into account their expertise and then you discard it. And that is no doubt because the policies that they were considering in those cases were policies that applied to a large run of cases going through the system, and decision-making by officials at all levels, including the most junior, in relation to the run of cases. That's why I say it all depends on the policy and what you're doing with it, because there may be different bits where you are, I don't know, for example, designing a particular specialist part of the system where the argument might play in the context of immigration. But again, one doesn't need to solve all the ills of the world in one go. The fact of the matter is that here we have a paradigm example of a short, crisply expressed set of terms of reference being operated by people who are appointed for the specific reason that they are expert in this field. And my submission is that that is a fortiori the sort of context that led to the principle in the planning context that Lord Carnwath was talking about. It is directly about particular expertise in a particular context requiring it. And so I don't really care whether in certain parts of the immigration world you might be able to say that some people are expert in it because they do it day in, day out, but it's a very different circumstance, and the circumstance in which they are expert is non-comparable. But if you take the base principle as one which is tethered to expertise, and that's how it's expressed.
I just wanted to be sure that you were going to meet the point that is put against you. That's the reason.
Well, my Lord, that's my answer. My answer is it's a principle that is tethered to expertise. Here we have an absolutely paradigmatic case of expertise, and that renders the application of the principle described by Lord Carnwath in the planning context as being a fortiori applicable. And it certainly cannot be dismissed on the basis that it was all about planning.
Well, I mean, I'm not going to you're going to take us to the cases that you think are relevant, but it was pointed out in argument that the Hopkins principle was not referred to in later cases where they came back to the good reason approach.
In the immigration sphere. But the only case in relation to which that point was made, or the principal one, was the Hamati case, which you'll recall.
I do.
And the Hamati case was again a very different context. It was about detention in the immigration sphere. It was a broadly expressed policy that cut across all forms of detention in that immigration context. So not a context that attracted that sort of expertise analysis. And the issue there, the principal issue there, was whether or not the policy was to be treated as being law, in inverted commas, for the purpose of EU law. as you'll recall. You see that from the context in the head note, which you will remember. And so the significance of Hamati is not to undermine in any way the statement of principle from Hopkins Holmes at paragraph 25, also unanimous Supreme Court, with its tethering to expertise. The explanation for the non-reference to that case is either the total incompetence of counsel representing the government in that case, or because the Supreme Court, and indeed counsel representing the government, did not regard that principle as being relevant in that particular context. So we respectfully submit that the absence of reference to Hopkins Holmes in Hamati cannot possibly be equated, which seemed to be the suggestion, with the idea that the Supreme Court were in some way, shape or form restricting the application of the principles set out by Lord Carnwath in paragraph 25 solely to the planning context. There is no suggestion whatever that the Supreme Court thought it appropriate to row back from that principle or to disagree with it. So that's what we say by way of principled answer to the way in which this is sought to be attacked by my learned friend and the case law on which she relies. It's perhaps also worth picking up on the basis that one's considering what government policy is for this purpose, and I'll come back to this point by reference to the Good Lord project, which, my Lord, I know the Master of the Rolls will recall. But it is at least worth remembering that in at least one of these cases, the Supreme Court in the Friends of the Earth case did address and did consider what, when described in legislation, the concept was government policy. That was a legislative term that they were considering, and they considered what that meant. And it is perhaps worth reminding you of that when considering this matter, if only to flag it. If you go, it's not in the bundle, but if you go to Friends of the Earth isn't in the bundle, but if you go to the judgment at paragraph 152, and the second paragraph, the second half of 152 on page 131, do you see a reference to Friends of the Earth, Supreme Court Friends of the Earth in 152, halfway, about 7 lines down, page 131? Can I invite you to read from there to the end of the paragraph? So there they're calling for something which is so clear and unequivocal because they're tying it to the reference to legitimate expectation. Again, to some extent, it's a throwback to the basis of principle from Nadaraja, but you see an application of it in Friends of the Earth there. And of course, if it's tied back to legitimate expectation in order for anything to get off the ground in the context of legitimate expectation, you have to have a promise of a certain nature, as you're very well aware. Lord Bingham and MFK, clarity and unequivocality being the moniker or the yardsticks of that sort of thing that would qualify as a policy. And there in Heathrow, they were saying, Friends of the Earth, they were saying in order to get within the statutory concept of a government policy, you have to have a policy of that kind. And there was a dispute about oral statements or ministerial statements and whether they amount to policies. Very different context, but it's that link back to the idea that you don't fall within the rubric, as it were, unless you've got that degree of clarity. So we submit that those are the principles of interpretation. No one is abandoning or inviting you to abandon the role of the court in interpreting these sorts of documents. I've accepted that as my first proposition. It is the role of the court. But the question, as ever, is how, in principle, does the court go about doing that? And there you have all of the notes of caution that I've indicated, including not treating it like a statute, including starting from the presumption when you're in an expert context that they've understood the policy framework.
But that's not a presumption that applies of any relevance in considering what the meaning of the document is. It doesn't matter whether they understood it or not. You first of all have to work out what the meaning of the document is, and then it'll answer itself whether they understood it correctly. I mean, you may take into account what they say, I suppose, unusually for an interpretation exercise. You may take into account what they say they thought it meant, but it wouldn't be the first thing you'd do.
No, how they acted on it. But I mean, that's partly why I said when you go back to Hopkins Holmes, you need to read the 2 or 3 paragraphs preceding paragraph 25, because those do make it clear that the approach in para 25 is an approach that is relevant and treated as being relevant to the exercise of interpretation. Now, of course, it doesn't solve it because the court's still got to do it.
Yeah, I mean, if it were if it were a contractual exercise, you would not be permitted to consider evidence.
Or an exercise of construing a statute. You can't turn up and say, I intended it to mean this.
Well, with a statute, you might have a pepper and heart, but with a contract, you wouldn't have pepper and heart.
Or perhaps it's somewhere.
This is more similar to a contract because this is interpreting. The reason we use the word interpreting rather than construing is because it is not a statute.
Well, my lord, quite. But these are principles that have been developed in the very context for the purpose of trying to assist the court in how it goes about the approach of doing that. Because this is a strange hybrid business. You're dealing in part with.
Do you accept that on a plain reading of the document, although it actually doesn't say it, that there is an apprehension that an RMB will be procured in the decision-making they were thinking about in the terms of reference?
In the usual case, yes. It's describing the key tasks.
In the situation they were thinking about, which is what no doubt RAVC does every day, they would normally get an RMB.
Yeah.
Well, that takes that sort of clears away a lot of the undergrowth there, doesn't it?
It does. And I'm not going to quibble with that, the usual approach. The question is whether it's as it were, an absolute obligation.
You say there's nothing in
all cases.
The document that refers to a situation of the kind they were dealing with here, so the thing was more open.
That's what it'll come to. Can I come to the application of those principles? One can debate them uphill and down dale, but that's what we say in answer to my little friend's point on Hopkins Holmes. So I don't want it to be taken as an overstatement of our position. We're not saying it applies across the board. We're saying it applies that framework point only in the context of particular expertise, and that isn't restricted to planning. So the application here, the 2017 terms of reference, you have them in the supplemental bundle at page 168, tab 11. They're summarised in the judgment at paragraph 71, and the relevant bits from paragraphs 20 and 21 are set out verbatim, quoted by the judge in paragraph 79 of the judgment. You'll have seen them there. The role of RAVC and the chair in particular is described, as you've seen, paragraphs 1 to 5 of the terms of reference. And C for the chair, and his role, paragraph 72 of the judgment. And the appellant does here rely on what we say is an unduly strict reading of the words at paragraph 20 of the TOR, outlining RAVC's key tasks. The executive committee will, and then coupled with the third bullet is her case. The judge found that here, as elsewhere, the appellant's case had adopted and proceeds from an inappropriately formalistic interpretation of the RAVC process as if it was a statute, which approach was, as the judge put it in paragraph 201, entirely inapt for the sort of decision-making with which we are here concerned. See also paragraph 178 on the same theme, and the judge concluded at 162 that the words could not be taken, as it were, as imposing an obligation in all cases, and shouldn't be treated as if they were to be applied dogmatically. And we submit that he was entitled and correct so to find. The basic nature and context are critical, we submit. My learned friend's submissions on the policy documents, including this one, seeks to portray them as having some sort of binding nature, as setting out some sort of mandatory set of rules to be applied by rote, when there are no such thing, we submit. And given the nature of some of the submissions that have been made, it is perhaps important to remind the Court of the point made by the Supreme Court in the A case, when it came to review how policies worked and how they should be approached by the courts when challenges were sought to be built upon them. You'll remember the case in question where the judgment was given by Lord Sales and Lord Burnett together for the court. And they said, as you will recall, this is page 905 to 906, policies are different from law. They do not create legal rights as such. That was a passage that was quoted, as my Lord will recall, at paragraph 56 of the 2023 Good Law Project case. Paragraph 56 is at page 994, and the Court of Appeal in that case, again as my Lord the Master of the Rolls will recall, went on to emphasise in that paragraph why that statement, in constitutional terms, why that statement by the Supreme Court was so. So a set of important constitutional reasons identified by the Court of Appeal in Good Law Project 2023, para 56. And that's why I say the nature of the context and of the exercise is key. Not all guidance or policies are the same, as was made abundantly clear. That was the central nature of the issue, as my Lord will recall, in the Good Law Project case. There are different types of policy. Everything depends on context. Everything depends on the specific facts. And it's no good, it might be thought to be something of a flaw in my learned friend's approach to the principles that she set out at the very beginning of her submissions, which is you can't simply take a bunch of principles from a whole variety of different contexts and then present them as though they were absolute or general. Almost everything in public law is critically dependent upon context, and our context is no exception. We make 5 submissions on the basic nature and context.
Is now a good time to start with 5 submissions?
My Lord, I can break if that would be convenient. We're going to run up at a hard time difficulty at some point in this case, I suspect.
Well, you can make 1 or 2 of them.
No, I don't want to trouble you if it's been a long day.
If there are 5 submissions you're going to read out, I'll tell you what you can do is you can send them electronically overnight, and then you can get them through much more quickly in the morning.
Yeah.
And I still urge Miss Fatima to get her team to send her principles in writing, but electronically, please. Okay, well, we will break there. We will have a bit of a time issue, Sir James, so we'll try not to interrupt you as we tried, perhaps unsuccessfully, but mostly successfully, not to interrupt Miss Fatima tomorrow. And I would urge you to be as economical as you can, so that nobody feels hard done by the time pressures. Very good. 10:30 in the morning.